Okay, and and if we start at 11:05, it's 5 minutes. Right, thank you. Yeah. Let's see.
reminded us that in the 1940s, Chairman Mao called for the world to recognize the people of Taiwan's right to their own self-determination. He compared them to the Koreans and to the Vietnamese who had that similar right. That shifted in the decades following and continues to shift today, where, as we saw in evidence, the People's Republic of China continues to interfere with that right of self-determination of the Taiwanese people. And so I'd like to open with this quote from Chairman Mao, which is very appropriate for today's discussion. He said, when he launched the 100 Flowers movement, "Let 100 flowers bloom, weave through the old to bring forth the new." And it's appropriate to recall those words as the court considers the confirmation of the aggression charge today, because two tests exist under the international law theories for determining whether Taiwan exists as a state. One of those tests is old, and the other is new. The old test has been weeded out and replaced by the new. That old test, Your Honors, is the constitutive theory of statehood, the theory that the defense has brought up time and time again over the course of this week. That's a theory that looks to mere formalities when determining whether a state exists in the international order. It looks to whether other states recognize it or not. And it's a theory that allows for the rights of peoples, sovereign nations, to be denied simply by allowing other states to deny that an entity exists as a state. That theory, old, outdated, and obsolete, has been replaced by the new theory of statehood. The only theory of statehood that's reflected in both customary international law and conventional international law.
Does this court have the power to replace the theory if it finds that it has not been fully replaced?
National Court of Justice, in his perhaps the most impactful essay ever written on this question in the Yale Law Journal, held that the declaratory theory is what is used to determine when a state exists. And once the criteria of the declaratory theory of law are fulfilled, states then have an obligation to recognize. And so when states fail to recognize, it isn't that that is what denies the theory of the existence of an entity as a state, but rather the failure of recognition represents the breach of states' own duties to confer to other entities the rights and obligations that they deserve under international law. And I would submit, Your Honors, if you decide not to agree with the prosecution in pursuing the declaratory theory and ignoring state recognition, that you adopt Judge Lauterbach's theory as the proper approach. But as we'll also get to, questions of Taiwanese statehood are not dispositive in this case, because China's aggression also covers multiple other nations across the region, including the Philippines, Australia, Japan, the United States, the list goes on. And our alternative theory, the customary international law theory, does not require a showing of statehood of Taiwan in order to find that the crime of aggression, or what it used to be called under customary international law, the crime against peace, had been committed. But Your Honors, I would ask that you disregard this old, obsolete theory, and I'll give you just a very brief compendium of decisions over the last 2 centuries that have shown the shift from the formalistic approach of international law to the current approach, which elevates substance over form. And this started in the common law in the 1800s, Your Honors, with the concept of contracts. Contracts under the common law historically have required consideration, and parties wishing to overcome consideration might offer nominal consideration. In 1861, the case Schnell versus Nell held that merely offering a penny to try to show that consideration existed in a contract was insufficient, and absent real consideration, a contract did not exist. Fast forward to the 20th century, in 1923, the German settlers case held that after borders had changed after the First World War, Germans that had been living in what were now Polish territories, their fundamental rights had been violated, that these German settlers' property rights had been violated, and there had been a law on the books that had been neutral on its face, but in its application, the substantive rights of the German people were being violated. The Permanent Court of International Justice held that it wasn't what the law said that mattered. It mattered how the law was being applied that mattered. And this concept went also into the laws of armed conflict and use ad bellum, which is the law that applies to the legality of the use of force and when a use of force exists that triggers an armed conflict. In the 1939 Kawasaki case, Kawasaki versus Bentham steamship case, this was a case brought in the Court of Appeals in England. In that case, a dispute was a charter party between two private companies. One party argued force majeure on the basis of an armed conflict between China and Japan. The other party argued there could be no armed conflict between China and Japan because there had been no declaration of war. The court held that it was absolutely absurd to allow for a state's recognition of an existence of war to be the determining factor when Chinese and Japanese militaries were torpedoing each other's ships and engaging in other acts that constituted armed conflict. In that case, the court held it was the substance, the reality on the ground that mattered, not the recognition of states, which can in many cases be arbitrary. And finally, I would point your attention to the Geneva Conventions of 1949. Those conventions codified the precept in the Kawasaki case. We no longer need to wait for states to recognize through declarations of war in order for the armed conflict, the laws that govern armed conflict to apply. Today, under Common Articles 2 and 3, it's merely the resort to the use of force between high contracting parties, regardless of whether they have declared a war, and it's merely the existence of armed force between non-state armed groups or organized armed groups that's sufficient to trigger the application of the laws of war. We've moved away from formalities, Your Honors, to the age where substance is what matters. And how do we know, Your Honors, that what I'm telling you is the truth, that it is, in fact, this new theory? I'll just give you a very brief compendium of some of the academic literature. As you know, Article 38 of the Statute of the International Court of Justice allows us to rely on the most qualified and highly qualified publicists of international law as a subsidiary means of determining what the content of international law is. What has Anne Orford and Florian Hoffman stated in their Oxford Handbook on the Theory of International Law? They state, and I quote, "The passage of the 4 Montevideo criteria into customary international law marked the beginning of the end for the constitutive theory and for the so-called standard of civilization upon which it relied." Now, if I may interpret that, the only words from this court that the constitutive theory deserves are the words of a post-mortem. Professor Malcolm Shaw, in the 5th edition of his treatise International Law, states, and I quote, "Practice over the last century," and he's referring to the 20th century here, "does point to the declaratory approach as the better of the two theories. States which for particular reasons have refused to recognize other states, such as the Arab world and Israel and the USA and certain communist nations, rarely contend that the other party is devoid of powers and obligations."
I'll suggest to you that maybe a post-mortem is even unnecessary, but carry on.
Thank you, Your Honor, and I would agree with that. Finally, the ICJ, former judge Lauterpacht, in his article, "Recognition of States and International Law," writes, "A state exists as a subject of international law, as a subject of international rights and duties, as soon as it exists as a fact. That is, as soon as it fulfills the conditions of statehood as laid down in international law. Recognition merely declares the existence of that fact. To recognize a community as a state is to declare that it fulfills the conditions of statehood as required by international law. If these conditions are present, existing states are under the duty to grant recognition." Now, Your Honor, throughout this case, the defense has focused on the wrong law and the wrong facts. They have stated that in 1971, the United Nations shifted recognition of the Republic of China to the People's Republic of China as the proper and legitimate seat at the General Council, General Assembly, and at the United Nations Security Council. We have repeatedly said that we're willing to stipulate into facts that Taiwan is not a member of the United Nations, but that is irrelevant for purposes of determining its statehood. Just as irrelevant as the fact that Liechtenstein, prior to 1990, was not a member of the United Nations, and yet it was a state. Just as irrelevant as the fact that Switzerland, prior to 2002, was not a member of the United Nations, and yet it was an internationally recognized state with all the rights and obligations of statehood. They focused on the World Health Organization and the fact that Taiwan, due to the PRC's actions, has been excluded from the WHO. We submit to you, Your Honors, that this is irrelevant for purposes of determining statehood, just as irrelevant as the fact that Liechtenstein and other states are not members of the WHO, just as irrelevant as the fact that the Holy See, which is recognized as a state, as a citizen in the international order, is not a member of the United Nations. They focused on a non-binding United Nations General Assembly resolution, which has no binding power under international law. Declarations are merely aspirational international law, and the only binding effect they have is on passing the budgets of the United Nations, which is irrelevant to the matters before us today. Having now established the statehood of Taiwan, I would like to turn the court's attention to the acts of aggression against Taiwan.
And I'd like to particularly hear you on whether they were intense enough and whether they went far enough. That's what I'd like to hear you on, particularly, but carry on.
Your Honor, this is not a case of China sending a ship to the territorial waters of Taiwan and firing a single round. That would have been a violation, certainly, of the territorial integrity and the sovereignty of Taiwan, but it wouldn't have risen to the level of a manifest violation of the United Nations Charter. But that is not the evidence that we have before us today, Your Honor. The evidence that we have before us today is that China fired 11 ballistic missiles, at least 5 of which passed through Taiwanese territorial airspace. We have argued since Monday that the territorial airspace is the entire column of air above Taiwan's territory and above its territorial waters. This was a manifest violation of the territorial integrity of Taiwan. We have provided evidence, Your Honor, multiple credible sources of at least 5 missiles being during drills, both just as well as in 2022. We have provided evidence from expert witnesses that China conducted powerful cyber attacks against both Taiwan's private sector and state authorities. Acts of war no different than acts using kinetic force under the Talon Manual on Cyber Operations and under the Advisor's Report on the Crime of Aggression under the Rome Statute. We have provided evidence that China held military drills in May of 2024 as a strong punishment for the nation's inauguration of a pro-independence president whose only crime was to call out and state, stop threatening the island and accept the existence of its democracy, end quote. We have provided evidence, Your Honors, of extensive attacks by both the Chinese maritime militia, which our expert witnesses have argued have fallen with the effective control of the Chinese state, as well as China's Coast Guard, of Philippine ships in international waters in both the South China Sea and the West Philippine Sea. One expert, Mrs. A, produced an open source photograph of the roof of one such ship that had been torn open by water cannons, which our expert, Dr. J. Batongbakal, the leading expert on the law of the sea in the Philippines, said were so powerful that water lasers are used to cut both steel and diamonds. Dr. Batongbakal testified that China's operations in international waters are a violation of UNCLOS and other international obligations, which are an affront to not only the UN Charter, but other international human rights law treaties and treaties that codify the rights of sovereignty of states in the international order. We watched a video of the President of the Philippines condemning the attack as an unprovoked aggression. In Australia, we heard from our expert, Mrs. A, who testified that in 2022, the PRC used military-grade laser to illuminate an Australian Air Force aircraft in flight to enforce sanctions against North Korea, putting its pilot in grave danger. We watched a video of Australian Prime Minister condemning the attack as an unprovoked aggression. Mrs. A also recounted an incident in May of 2024 where a Chinese Air Force jet fired flares in the path of an Australian Seahawk helicopter, forcing the pilot to take evasive actions. We produced into evidence a resolution of the European Parliament where 424 parliamentarians, 97%, condemned these as unprovoked acts of aggression. We produced a witness, Mr. John Dobson, who testified that Chinese cyber attacks against the United States took down the entire network of the United States Naval War College for 2 weeks. He testified that China's state-sponsored actor Volt Typhoon designed to disrupt U.S. communications infrastructure and targeted Guam. He testified that APT-31, a collection of Chinese state-sponsored intelligence officers and hackers that targeted high-ranking United States government officials. He testified that on a daily basis, China's cyber attacks run in the thousands, if not the tens of thousands. Finally, we reviewed documentary videos showing at least 5 Chinese ballistic missiles that were fired at Japan in 2022 and landed in its exclusive economic zone. Now, Your Honor, I just wish to turn your attention to the requirement of the Rome Statute of a manifest violation. I will submit to you that finding a manifest violation of the UN Charter is not required today under the customary international law, alternate charge that we produced. But should the court confirm the charge under the Rome Statute, it must find an attack that, based on its character, gravity, and scale, constitutes a manifest violation of the UN Charter. I would submit to you that China's launch of 5 missiles over Taiwan in 2022 constitutes a violation of Taiwan's territorial integrity, which is the most fundamental and primordial of all the rights under the UN Charter. That China's barrage of 13,000 cyber attacks per day, which according to our expert John Dodson, peaks during democratic elections and peaked most recently at the inauguration of Taiwan's pro-independence candidate, is a violation of Taiwan's political independence. There is no than that of free and fair elections, and China violates that provision each time it interferes with elections through cyber. To that the extent of damage that the PRC has caused and lost the limb rises to the level of gravity required under the Rome Statute. Your Honor, we saw documentary evidence of at least 2 Filipino fishermen whose lives were devastated by Chinese actions in the South China Sea. We watched one of them, who was once a young, healthy, able-bodied man who supported for his family as a fisherman, who now had been rendered invalid due to the traumatization of being in international waters and then having his ship onboarded by a Chinese vessel. He now can no longer walk, he now can no longer talk, his wife must speak for him, and his family has been reduced to poverty. His wife tries to make ends meet, Your Honors, by selling rice cakes in the Philippines' depressed economy. I submit to you, Your Honor, that psychological and physical trauma constitutes the loss of limb that rises to the level of gravity under the Rome Statute. We also heard another video of a second man who, after being chased by Chinese ships, now suffers panic attacks every time he sees a ship on the horizon. That man can no longer speak straight, he stutters. These are physical manifestations of the psychological impact of Chinese aggression on these seas, Your Honor. Seas that our expert, Dr. Batangpakal, has stated that China has no right to control. Finally, scale, Your Honors. Here we consider the sheer number of China's attacks as meeting the requirement. The ICJ, in its 2003 oil platforms to judgment, and in its 2005 armed activities in the territory of the Congo decision, left open the possibility of meeting the requirements for an armed attack based on an aggregation of multiple attacks. Your Honor, we're not talking about a single missile attack or a single round fired across a state border. We're talking about thousands of attacks on a daily basis, kinetic, gray zone, cyber. These rise to the level of scale required under the Rome Statute for you to find the defendant's responsibility today for the crime of aggression. Next, we turn to the element of responsibility. The Rome Statute requires that a person be in a position to effectively exercise control over the political or military action of the state that committed the aggression. As demonstrated in Prosecution's Exhibit F8, the defendant is the quintessential person in a position effectively to exercise control over both the political and the military action of China. He served as the General Secretary of the Chinese Communist Party and Chairman of the Central Military Commission, and thus the paramount leader of China since 2012. He's also been the President of the People's Republic of China since 2012. As General Secretary of the Chinese Communist Party, he serves as the Commander-in-Chief of the Chinese military. As Secretary General of the CCP and Commander-in-Chief, he effectively directs both the political and military acts of China. And the last element, Your Honors, mens rea. It's a very low standard, Your Honors. We don't have to prove intent. We don't have to prove purpose. We don't have to prove recklessness. We only have to prove knowledge. The Rome Statute refers to awareness of the unlawful use of force that established a manifest violation of the UN Charter. Mere knowledge, Your Honors. It would be unreasonable for anyone to stand before you here today and argue that the defendant is unaware of these attacks over the past decades, Your Honors. It would be unreasonable for me to argue that he is unaware that in 2022, 97% of European parliamentarians who voted on China's acts of aggression in Taiwan condemned them as unacceptable acts of aggression that needed to have consequences. It's not possible that he would not know following summits with European leaders that condemned the attacks. It's not possible he would not know of condemnations by presidents and prime ministers from neighboring states, the Philippines and Australia. We showed you those videos earlier this week. They condemned attacks of their ships, attacks of their helicopters, attacks of their Air Force jets. As a political leader who sought to iron out China's frayed relations with the European Union in his most recent visit 3 months ago, the only possible way that he would not know of this endless barrage of attacks is if he had only the most incompetent of advisors fully incapable of informing him of the most important and pressing issues straining Chinese-EU relations. Your Honors, this court must conclude that he is at least aware, if not directing, these attacks. Finally, Your Honors, should you not find the prosecution that China's acts against its neighboring states may be confirmed as charges under the alternative argument that we've proffered, aggression under the customary international law standard, which is permitted under the statute of the Court of the Citizens of the World. The Court of the Citizens of the World defines aggression as found in the Nuremberg, the customary international law definition defines the crimes against peace as it's found in the Nuremberg Charter, which according to the most highly publicized publicists of the law, including Antonio Cassese, is an affirmation of the principles of international law recognized by the Charter of the Nuremberg Tribunal.
Just to take you back a little, as I understand Chinese society, if the president disagreed with any of these attacks, we would have known that there would have been consequences in China, wouldn't they?
Thank you. Yes, Your Honor.
Right.
I fully agree with that statement. How does the Nuremberg Charter define aggression? It defines it as the planning, preparation, initiation, or waging of war of aggression, or a war in violation of international treaties, agreements, or assurances. Here, I wish to draw your attention to the fact that, unlike the Rome Statute, the Nuremberg Charter does not require an actual act. Mere preparation or planning may be sufficient. Moreover, no manifest violation of the UN Charter is required. Therefore, if the Court of the Citizens of the World does not find the crime of aggression under the Rome Statute, it could, in the alternative form, find crimes against peace under custom. The Nuremberg Charter does not require a finding of statehood of the victim of aggression. And even if it did, we have ample evidence of aggression against the Philippines, Australia, Japan, and the United States. With respect to planning of war of aggression, even if the court does not find a single act that the defendant committed to be an actual act of aggression, it can still confirm charges for him in the alternative charges brought against him as stated in the indictment, namely planning or preparing. The prosecution has produced extensive evidence for the charge of planning or preparing, including, as found in open sources, China has 2,000 short-range missiles pointed at Taiwan. What other possible purpose could those missiles have other than launching an act of aggression? China has developed cyber weapons such as Volt Typhoon designed to disrupt communications in the event of an invasion. Why would they seek to disrupt communications, Your Honor, in the event of acts of aggression, of course? China has engaged in full-scale military exercises such as air and naval blockades in 2022 and 2024 designed to simulate combat. China has fired missile systems across Taiwan airspace and into Japanese water. These all can be construed, Your Honors, as substantial grounds to believe that China is planning a war of aggression in violation of multiple international treaties. the United Nations Charter, of course, but also UNCLOS, which our expert, Dr. Jay Batam Bakal, argued contains a provision that requires states to exercise their rights with due regard to the rights of other states, as well as the Chicago Convention, and international civil aviation, which also has similar due regard language with respect to the use of airspace. Finally, Your Honor, before I close, I wish to draw your attention to the very, very low evidentiary standard that stands before us today. And for this, I wish to turn to this very thick and intensely researched treatise on international law. This is Archbold's International Criminal Courts, which states on page 368, the confirmation procedure should not be disregarded as a means to distinguish those, should be regarded as a means to distinguish those cases that should go to trial from those that should not go to trial. In order for the prosecution's evidence to meet the threshold of substantial grounds to believe, the evidence must go beyond mere theory or suspicion in order to protect defendants against wrongful and unfounded charges. Your Honor, I would submit to you today that the prosecution has gone far beyond mere theory or suspicion. To demonstrate if this case takes us to trial and we're required to prove beyond a reasonable doubt, that number may be way up here, let's say a 99, and here I have my hand up in the air, Your Honor. If we're required to show by a preponderance of the evidence, that number may be down here, and here I have my hand by my waist, let's say a 51.
Yeah.
Substantial grounds to believe, Your Honors, is far down here. And here I have my hand by the sole of my shoe. I would give it a 20 or a 25, maybe a 30, but not more than that.
Unfortunately, you can't get underneath the sole of your shoe.
Your Honor, that might be probable cause, which is the only standard that's lower than that. Conclusion, the court must ask the prosecution's evidence of China's acts of aggression against Taiwan, against the Philippines, against Australia, against Japan, against the US, go beyond mere theory or suspicion? If the answer to that question is yes, then the court, speaking as the voice of all the citizens of the world, must confirm the charges. Thank you, Your Honors.
Thank you very much.
Are we going to go, wait just a second.
Judges, we anticipated that the prosecution.
No, I think as much as we'd like to hear from the defense, point by point,
No,
I think our intention.
Just go ahead.
We're all prepared to respond to each other.
Can I say, as far as the prosecution.
So do you want to do
Wait just a
I'm
moment.
not objecting to it.
Yeah.
I just was taken aback as I'd assumed that we were going to deliver the prosecution close and then the defense. If the defense would rather do it in that way, it speaks for myself, I have no objection to it.
Do you have any problem with that?
No
On-
problem. Okay,
It's a
That's
matter
fine.
for the
So
court.
proceed as you.
30 minutes starting now.
Okay.
All right,
Right.
at 11:05. Your Honors, the defense advances this proposition. There are two components to the defense in respect to the count of aggression. The first is that the acts in evidence may or may not be acts of aggression, but they do not individually or collectively constitute the crime of aggression. The other issue here is that Taiwan, for the purposes of the Rome Statute and for the purposes that bring us here today, is not a state so as to engage 8 bis of the Rome Statute. Now, if I can begin with a discussion of the question of whether or not the acts constitute acts of aggression or a crime of aggression. We begin here with the Charter of the United Nations. And just for your review, this is document 3, you don't have to go there. And it says this, the Security Council may, in conformity with the Charter, conclude that a determination that an act of aggression has been committed, that it would not be justified in light of other relevant circumstances, including the fact, a finding, the point here being, there can be a finding of an act of aggression that doesn't constitute the crime of aggression by virtue of, in these words, in light of other relevant circumstances, including the fact that the acts concerned or their consequences are not of sufficient gravity. Now, those words drawn from the United Nations Charter are mirrored in 8 bis itself, where it says,
is the test qualitative or quantitative?
I beg your pardon?
Is the test qualitative or quantitative?
I think it's
Sufficient gravity.
Yes.
Yes, carry on.
8 bis says this, an act of aggression, not any act of aggression constitutes the crime, but it says this, an act of aggression must be one which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. Now, what's the most contemporary rendering of that proposition? And I think it is a 2021 discussion by the Council of Advisors report on the application of the Rome Statute to the International Criminal Court on cyber warfare. This advising panel said this is about the use of cyber warfare, but it applies across the board. This has been, meaning 8 bis, this has been read to mean that a breach of the prohibition of the use of force will only amount to aggression where it is a grave violation with serious consequences. In other words, it ensures that only serious and unambiguously illegal instances of the use of force by individual criminal responsibility of a leader of that state under the statute. That the manifest violation requires an inquiry into the magnitude of the unlawful use of force. It's clear that the use of the term manifest, meaning clear, apparent, and evident, the act must be more than an illegal use of force. This concept has been accepted by this court in Judge Rapp's ruling on the Vladimir Putin confirmation hearing. He said this. This can be found in document 13. Quoting, Article 8 bis sets forth a 2-step process. First is a determination is required that certain defined that acts have been committed. Then, and only then, it must be determined whether the acts were of such a character, gravity, and scale so as to constitute a manifest violation of the UN Charter. Now, so with that 2-step analysis and the notion of gravity in mind, what do we have here? Well, perhaps I'll do this. What are the antecedents of this offense? What are the acts and events in history that have given birth both to the United Nations, the Charter, and the Rome Statute, and finally, Section 8 bis? What are the events that are being talked about here? The history of the discussion and evolution of this count, it's clear that it was the invasion of Poland, and I've said to you in my opening, the mass horrors that followed the bombing of Pearl Harbor and the millions of deaths that arose, and only most recently in this court, the hundreds of thousands and counting deaths in the Ukraine. This is the conceptual backdrop in respect of which you are being invited to put the acts that have been proven for you on the same plane as those events. It is palpably not possible for this court to do that. If I could take you to, importantly, during the discussions that gave rise to 8 bis, there is annexed to the resolution itself a document called Other Understandings that is part and parcel of the amendment that brought HBIS into existence. And those understandings, which are part of the statute, say this. And that can be found for later reference as document 15. This is what the statute itself says in its annex. It is understood that aggression is the most serious and dangerous form of the illegal use of force, and that a determination whether an act of aggression has been committed requires consideration of all of the circumstances of each particular case, including the gravity of the acts concerned and their consequences, in accordance with the Charter of the United Nations. And at paragraph 7, it's understood that in establishing whether an act of aggression constitutes a manifest violation of the Charter of the United Nations, the three components of character, gravity, and scale must be sufficient to justify a manifest determination. No one component can be significant enough to satisfy the manifest standard by itself. The origin of this offense was described as at Nuremberg as the crime of crimes, otherwise described as the most serious of the most serious offenses. And why is that? As has been described previously, because this crime has within it all other of the horrors, all other of the crime. It's the crime that looses the dogs of war. It is the most serious. And as I'm saying this, to reflect at the same time, we're talking about water cannons that bent some metal. We're talking about military people who were frightened and put in danger. We're not talking about a single loss of life. Not one. And that is aggression? And consequences. What are the consequences here? People are very annoyed. Let me go back to the indictment itself.
The damage to property was limited to the damage to the roof of one ship, wasn't it?
Yes, it could have been that serious. The indictment reads, the complaint, A, as an illustration of the averment of the act that constitutes aggression, firing 11 ballistic missiles, at least 5 of which passed through Taiwan's territorial airspace. Okay. Assume that is made out. But I do say to you that Dr. Chow volunteered in chief, and he was the prosecution's expert, said he was uncertain if they entered Taiwan airspace. Ambassador Mei Xinjiang, who, according to the schedule, was to establish breaches of territorial sovereignty and airspace, had absolutely nothing to say about it. So did it, in fact, intrude on Taiwanese sovereignty? I don't think that's established. But even if it were, it can't possibly amount to an act of aggression, or certainly a crime of aggression. And you ask what harm was done. Do we know if this missile was armed? Did it ever presented any real threat to anyone? This is more in the nature of an exaggerated form of littering than the crime of aggression. The next count is implementing an effective blockade on Taiwan's air and sea space during military drills. there's a dearth of evidence on that as well. But what we don't know is what was the nature of the interference? Was it interference with commerce? Were planes and marine traffic interfered with, and on what scale? Was there any economic cost to all of this? We just don't have that evidence. The next averment, C, is conducting a powerful cyber attack against Taiwan's private sector and state authorities. I only say this. There doesn't seem, even though we certainly have evidence that it happened, that there was any material consequence to this at all. We don't know what the implications of those actions were. Paragraphs D and M on the indictment charge firing 5 ballistic missiles that landed in the Japanese exclusive economic zone. You will see from Article 56 that's in the defense materials, Article 56 of the Law of the Sea statute, that the economic zones confer a very limited degree of sovereignty, specific and limited degree of sovereignty that a state has in respect to its economic zone. And what is it? It is this: the right to mine the sea and to fish in its waters and to benefit from the economics that can be derived from the sea. There is no other sovereignty. It's the high seas otherwise. For of the Roman statute and sovereignty, and it's simply not there on law. Paragraph E, planning a war of aggression by sea, land, etc., etc. Simply just no evidence of it at all. Continuing a war of aggression against, I'm looking at F now, continuing a war of aggression against Taiwan began in 1954 and then talks about the 96 election. This is outside the time frame of the indictment and it's totally irrelevant. The Philippines issue at paragraph J, interfering with the fishing activities and Coast Guard, certainly doesn't rise to the point of aggression. Using a military-grade laser and putting service people for the Royal Australian Air Force in jeopardy, frightening experience and unneighborly behavior, but not the crime of aggression. Firing flares in the path of a helicopter, and nothing in the nature of an act that could even get off the ground and get to an allegation of aggression. And the final count, M, is a duplication of the Japanese count and can be ignored completely. Now, the other issue here before you is the question of statehood, because, of course, it's critical. The offense here is one state against another state, and if either one, or rather the complainant is not a state, it cannot invoke the application of this statute. The test of statehood in respect to the jurisdiction of the ICC, what is it? Well, we don't know. Can you say, well, it is a question, I think, more of mixed fact and law. But I say this is a criminal tribunal constituted to deal with criminal offenses. It's not an international court of general jurisdiction that could be asked to settle the issue internationally of Taiwan's statehood. The international organ that gave birth to this very court is the principal source of international law for all intents and purposes of the United Nations.
Yes.
It's made very clear the issue of statehood for Taiwan. I ask you to consider that it is settled law, that it's been settled law since 1971. I won't take you through the resolutions, the resolution, first of all, that expelled Taiwan from the United Nations, the actions that have been taken by the United Nations to refuse admission to Taiwan. And I say it's not simply the act of refusing admission or expelling Taiwan, it's the reasons that the international community gave for doing so. They said it's an internal matter. Taiwan is part of China. There is only one China. That's the international community speaking, 193 nations, speaking for 99.9% of the population of the world is saying that, and they've said it repeatedly again and again and again. The United Nations speaks not only but from its organizations. This regrettably is a circumstance where the WHO would not even recognize Taiwan during the pandemics that we have had. It is the decision in the only reference I could find judicially was the decision in the Putin case, in which this court used the wording, though Russia has done its best to, if I can paraphrase, to make the case that the Ukraine never existed, that it's not a real nation, that it's not a real people, distinct from the Russian nation. This court said it's clear that the Ukraine is a state, so as to engage the charter. And I think that is as good a standard as any court could apply. Perhaps to add, manifestly clear that it is a state. And that is the case here. My friend invites the court to disregard the words of the United Nations, which is a breathtaking proposition in this courtroom, and yet, and rather than that, adopt a theory of what constitutes a state. You will find in my friend's materials, under the scientific materials, an article that says that there are 4 or even 5 theories of what academic theories as to what constitutes a state. And the academic, let alone juridical considerations, are profoundly inconsistent. But if you have to go, if you choose to reject a solid body of law for the last 50 years and opt for a theoretical construct, bear in mind the uncertainty even of that, and where ambiguity might reside in this proceeding. I, I only say this, that not only would such a finding fly in the face of settled law, it would go further and lend the imprimatur of this court to secession and ignite issues that could well do enormous harm. That's my submission. Thank you very much.
Are you done?
Yes.
You have, the defense now has a credit of 7 minutes for future arguments. Can we proceed with the second issue? Thank you.
Those are dangerous words, Judge. We'll be sure to use those.
Yes, no, but no more than.
No more than.
Your Honours, throughout this week, the court has heard evidence from 3 expert witnesses and 3 civilian victim witnesses about crimes against humanity in Tibet. Documentary evidence on the case file, together with these testimonies, establish substantial grounds to believe that the following crimes occurred in areas known as the Tibet Autonomous Region, the Tibet Autonomous Prefecture, and the Tibet Autonomous Counties. Count 2, being forcible transfer of a civilian population, and that is the Tibetan children who were separated from their families and taken into colonial boarding schools. Count 3, imprisonment or other severe deprivations of physical liberty of political prisoners and conscience. Count 4, persecution of the Tibetan civilian population, being the severe deprivations of their fundamental human rights, most notably their freedom of expression, association and assembly, social and cultural life. I've previously outlined the power system that President Xi Jinping holds over Tibet. In summary, firstly, there's a clear connection between the power of the Chinese Communist Party and the functions of the state, with all political strategic decision-making being made by the CCP and state government managing the daily affairs of civilians in accordance with CCP policies. And secondly, President Xi has exerted personal control over governance in an unprecedented way. Now, this has been made clear by Professor David Tobin's evidence this morning. As head of the CCP and head of the state, Xi Jinping has consolidated his control of governance through the removal of presidential term limits and prescribing Xi Jinping thought as a guide to action. It's important to note that the crimes that come within the temporal period of the indictment coincide with his positions as General Secretary of the Chinese Communist Party, Chairman of the Central Military Commission, as well as his presidency of China. His role as Vice President of the People's Republic of China in the period between 2008 and 2013 is also significant in terms of setting the scene for his knowledge and his participation in critical party policy from a time much earlier than his presidency. President Xi's model of governance is based on a centralised, personalised rule, focusing on modern and intensive modes of surveillance of the population, mass mobilisation, the removal of dissidents, and the forced imposition of ideological indoctrination, particularly the imposition into the constitution of Xi Jinping thought, and that being a socialist ideology with Chinese characteristics, and also the institution of Xi Jinping thought into school curricula. His Sinicization policy has gone further than the leaders before him. And as Professor David Tobin said this morning in relation to the Uyghur case, when facing an ethnic problem, the policy is development is not enough. We need to Sinicize them, and we need to make their identities disappear. The evidence from the experts who speak specifically about his policies in relation to Tibet is the same. Not only does his administration destroy monasteries and enact laws, guidelines and notices that criminalise traditional Tibetan practices, his policies positively target future generations. With colonial boarding schools, his aim is to create a whole new youth demographic of young Tibetans who speak only Chinese and have loyalty only to the CCP. Now, this court has heard from experts Langari Namgyal Dolkar and Darden Sharling and Dr. Sophie Richardson that Tibetan religious and cultural identity is deemed a real threat to the CCP. Each of these experts has studied extensively on the topics of China policies, human rights, and Tibet. Your Honour has heard that the defence tried to undermine each of these three experts on the basis that they are human rights advocates. But in the words of Dr. Richardson, Human Rights Watch work takes as its standard metrics the government's obligations in respect of human rights law, meaning that having an agenda to improve human rights in Tibet, or in the cases of Langari Namgyal Dolkar and Darden Sharling, being born in exile or coming from a family history where their parents and their grandparents have been political prisoners, does not render the methodical research, the technical information gathering, and the scholarly works of each of these experts to be less credible. Under vigorous cross-examination, each witness has displayed a firm standing with the rigour and thoroughness that they took to the research with which they were engaged. The lived experience of Ms. Dolkar and Ms. Sharling, including the fact that each is or has been a member of the Tibetan Parliament in exile, only strengthens the information that they have been able to impart. Now, why is Tibetan identity such a threat to the CCP, such that there is a need to eradicate it? According to Dr. Richardson, the Chinese leadership see the leadership of the Dalai Lama as being a threat insofar as it does not constitute loyalty to the party. The use of the word Dalai clique in state media and Chinese government documents is a scornful and derogatory term which references the Tibetan government in exile, also known as the Tibetan Central Administration. Expert Langari Namgyal Dolkar's evidence is that, and in her words, language is part of our identity. And in the words of expert Darden Sharling, the CCP realise that no matter what incentives or clampdowns they impose, Tibetans have and will stay core to their own identity. The Tibetan experts say that the threat to the CCP is so great that the only way to control this is to make Tibetans into Chinese, that is to signify them. Ms. Sharling says if Tibetans feel Chinese, then the CCP will have achieved what they have not been able to achieve in the last 65 years of occupation. Her evidence is also that before the policy of securitisation and sinicization had been ambiguous, but now the CCP have removed any pretense about these policies and they are now publicly expressed. In relation to religion, she gave evidence that the CCP wanted to make Tibetan Buddhism into Chinese Buddhism. After Xi Jinping came to power, the CCP launched a database where every Lama needs to be approved by the CCP, noting that the Dalai Lama himself is not on that list. Darden Sharling referred to this as political weaponization of this ancient tradition. Dr. Richardson stated that initially, the extent of the violent assimilationist agenda was not fully understood. The extent of violence is marked, the extent of violence that is marked by signification is being used to justify repressing religious practice. And this involves the arbitrary detention of monks and nuns whose only wish is to practice their faith, and deaths in custody due to lack of medical care, and the list just goes on. Under cross-examination, Dr. Richardson was asked whether there is a Chinese equivalent for the word signification. Her answer, there is a Chinese word. The actual translation is to make Chinese. Dr. Richardson was also asked about a whole range of semantics as the defence tried to undermine the sinicization measures of Xi Jinping by likening the term sinicization with the American phrase, America for Americans. Dr. Richardson's response was, you can take sinicization out of the documents and you can still be left with violations of human rights, both on paper and in practice. Now, in my opening, I meticulously went through various speeches of Xi Jinping about ethnic affairs throughout the period of 2011 to 2021. These are of utmost importance because these speeches are the critical link between the conduct, intention and knowledge of Xi Jinping relating to attacks upon the civilian Tibetan population based on their ethnicity, their race, nationality, and religion. These are shadow elements of crimes against humanity, which need to be established in the prosecution case. The events at which his critical speeches have been made include a 2011 visit to Tibet when he was Vice President of China, a 2015 speech at the 6th Central Tibet Work Symposium, which was held on the 24th to 25th of August 2015, and this was 3 years into his term as President, a 2019 speech at the National Conference on Mending National Unity and Progress, which was held on the 27th of September 2019, a speech during his unprecedented 2021 three-day visit to Tibet as President, and then an address that he made to the Central Conference on Ethnic Affairs in Beijing just 1 month after his visit to Tibet in August 2021. The key and repeating themes of Xi Jinping's speeches include fighting against separatist activities by the Dalai Group or the Dalai Clique, completely destroying any attempt to undermine stability in Tibet and national unity of the motherland, stabilizing Tibet's borders, fully and correctly implementing the party's ethnic policy and religious policies, socialism with Chinese characteristics, sharing the new glory and dream of the Chinese nation, the great motherland and the Chinese Communist Party, unswervingly carrying out the anti-succession struggle, unswervingly taking correct approaches with Chinese characteristics to handling ethnic affairs, ensuring national security and long-term stability, routinely crack down on all kinds of infiltration, subversions and sabotage activities, violent terrorist activities, ethnic separatist activities and religious extremist activities, jointly safeguarding national security and social stability, resisting the infiltration and subversion of extremist and separatist thoughts, working in the interests of the Chinese nation above anything else, and continuously eliminating his speeches in direct contradiction to what's happening on the ground. And expert Darden Charlin gave evidence that socialism with Chinese characteristics means stamping the CC brand on socialism. As for national unity of the motherland, it means all ethnic groups are part of the larger Chinese group, which is the motherland. And as for stabilizing Tibet or lasting stability, this is a political rhetoric which offers legitimacy to Xi Jinping and his party to further repress Tibetan civilians, was her evidence. Dr. Richardson also gave evidence about human rights work on a Tibet glossary of repression. Now, according to the methodical analysis of terms used in Xi Jinping's speeches and Chinese state party documents, cross-checking those against the reality of what measures are being conducted on the ground, Human Rights Watch says this: long-term stability or lasting stability, while sounding like a term that stands for a society that's free from conflict, violence and unrest, actually means, in the Tibetan context, the creation of a society in which there is no dissent. And according to Chinese political thinking in Tibet, this extreme form of long-term stability will be achieved by eradicating dissident ideas, which are seen as the root causes of instability rather than just the symptoms. Now, when cross-examined about whether a call for long-term stability in and of itself has sinister implications, Dr. Richardson responded, "One can't contemplate the term without understanding what this has meant in practice. One goes where the facts are. You can't leave out of semantics what actually happens to people as a result of these words." Now, Chen Kang-go also has a role, and the draft indictment specifies that Xi Jinping, together with Chen Kang-go and others, committed crimes against humanity in Tibet. So it's important to set out Chen Kang-go's role since his appointment in August 2011 as the Secretary of the Tibet Autonomous Region Party Committee for 5 years. Now, this is a time frame that overlapped with Xi Jinping's term as Vice President and then as President of the People's Republic of China. As Secretary of the Autonomous Region, Chen Kang-go called for tight control of Tibetans, including governance over all aspects of Tibetan life. In November 2011, he reported at the 8th Party Congress in Tibet about his ideas for stabilising work, including making the following speeches. He said, to carry out the anti-separatist struggle in depth, party organisations and party members and cages at all levels must take a firm stand, have a unified understanding, be consistent in what they say and what they do, have a resolute attitude and move in unison. They should closely rely on the masses of all ethnic groups to seek long-term strategies and consolidate their roots. He also said, we must persist in managing monasteries in accordance with the law, promote the standardisation and legalisation of monastic management, improve the management of the systems of monasteries and enrich the management of and strength of monasteries. And he goes on to say, we need to strengthen and innovate social management, implement the responsibility of maintaining...
Just 1 minute, Mr. Graham. Registrar, could you please tell those people responsible for that that we'll be breaking at 12:23 today, not at 12:30. Thank you. Right, proceed.
His speech goes on to say, we need to ensure that there are no gaps, no blind spots and no blank spots so as to resolve contradictions and problems in the first time and eliminate them in the bud. Now, these types of statements are a perfect example of the kind of newspeak and black-white which is coined by George Orwell in his novel 1984, where war is peace, ignorance is strength and freedom is slavery. According to the Human Rights Watch Tibet Glossary of Repression, which Your Honours had asked to see yesterday, the term no gaps and no blind spots means an order or guiding instruction to police, to party officials and to others, not to overlook or neglect even the most trivial location or aspect of a case that they're assessing, investigating or searching a village, a home or a monastery. It instructs them to investigate a person even when there is only the slightest suspicion that they might pose a potential threat to stability maintenance. And this instruction is repeatedly given to local officials in the autonomous region, ordering them to surveil all people who appear to be present, who appear to present even a slight threat. After his 5-year term in Tibet, Chen Guo in 2016 became Xinjiang's new party secretary. According to Professor David Tobin this morning, Xi Jinping chose Chen Guo because he was known to be strict in his methodologies with Tibet. Human Rights Watch reported that large-scale detentions of Tibetans for re-education in 2012 appear to have served as a trial for the ongoing, much larger-scale mass detention of Uyghurs in Xinjiang since 2016, and both drives were carried out under the direction of the same officer, Chen Guo. Now, under President Xi, Tibet has been securitized and closed to the world to prevent information about human rights abuses occurring inside Tibet from getting to the outside world and from information from the outside world from being accessible to Tibetan civilians. The evidence established that his administration utilises intensive surveillance of Tibet's population, including DNA collection, facial recognition, WeChat mobile phone monitoring, CCTV and other forms of modern technology. The fact witnesses Jigme Golok, the Buddhist monk who is in court today, Nima Lamo and Dondat Wanchen individually and cumulatively paint a picture of a truly Orwellian state. Even when they had fled from Tibet and now reside overseas, they are still being followed. And this court has heard similar accounts from the Uyghur victims who bravely testified in court yesterday. In terms of political prisoners, Jigme Golok, the monk, Nima Lamo and Dondat Wanchen were all former political prisoners. Dondat Wanchen and Jigme Golok were activists who created the film Leaving Fear Behind, and for that, Mr. Dondat Wanchen received 6 years and 3 months jail with hard manual labour and forced re-education and political indoctrination. Even though the period of their imprisonment and torture that they endured may not have strictly fallen upon the period within which Xi Jinping took presidency, it did fall within the period of his vice presidency. But more importantly, both men remained under constant surveillance and monitoring under his reign. And they both fell victim to the communication prohibitions, which restricted information flow inside and outside of Tibet, greatly interfering with freedom of speech and the right to engage in family life and cultural life. Mr. Jinping gave evidence that whilst he was on the run, living in the mountains in Tibet, he became aware of a Chinese warrant for his arrest on the 27th of November 2012. And this warrant had alleged that he had committed murder and offered 20,000 yuan for information about him. This was what prompted him to finally decide to leave Tibet. Tibet was no longer a place where he was safe, or could ever be safe. Once he was overseas, his brother was targeted for information on his whereabouts, and his brother was arrested and detained for maintaining communications with him. Your Honours have heard that WhatsApp, Signal, BBC, CNN, VPN, and the means of sending and receiving information to the outside world is prohibited, which makes it very difficult for Tibetan civilians to contact their families. Nyima Lamo's uncle, Tenzin Delek Rinpoche, was a revered Lama and a spiritual leader in Tibet who was targeted by the authorities. Charged with making an explosion or terrorism, which he did not do, and inciting separatism, he was initially sentenced to death, which was later commuted to life imprisonment. He died in custody in suspicious circumstances, and his niece suspected that he had been poisoned, but she received no satisfactory response from the authorities. She and her mother were arrested and detained for sharing with a family member in India a photo of her mum petitioning for the release of her uncle's body. When she was finally released, it was on condition that she not share the information about her uncle, that she stop investigating his death, and that she stop making requests about his case. And Your Honour has heard about a notice issued which outlined 7 forbidden activities, including prohibitions on attending funeral sites, forming associations to present petitions, circulating information, gathering with others in protest, raising funds for Rinpoche, idolising his picture, or memorialising the dead. Each one of these brave men and women came to court to shed light not just on their own experiences, but their experiences being representative of those who still suffer in Tibet today. Each story is laden with emotion. The decision to leave Tibet, their homeland, was a difficult one. For Nyima Lamo, it meant leaving behind her beloved daughter and suffering the torment of not knowing what has happened to her family since. Now, in terms of evidence in support of the charge of imprisonment and persecution as a crime against humanity, the tenet of that persecution crime is the severe deprivations of fundamental human rights. It's noteworthy that China, as a member of the state, as a member state of the United Nations, has affirmed acceptance of the Universal Declaration of Human Rights, and that Article 35 of China's constitution itself states, without qualification, that citizens are allowed freedom of assembly and association. The reality on the ground, however, cannot be more different. Aside from the victim narratives that Your Honours have heard, there's also been numerous examples during evidence of all the victim witnesses and expert witnesses, as well as documentary evidence on the case file concerning others who cannot be here to tell their own stories, who are also detained, prosecuted and persecuted. The Human Rights Watch report, Illegal Organisations, China's Crackdown on Social Groups in Tibet, contains numerous examples of the type of persecution which Xi Jinping is being charged. Dr. Richardson gave evidence that she oversighted the production of these reports, which were painstaking work, taking 3 to 5 years, doing the research, on-ground interviews, analysis of speeches and state documents by qualified and bilingual researchers, and Your Honours should deem the information from these reports to be credible and give significant weight to the contents of those reports. Hearsay evidence is permitted in these proceedings, and the documentary evidence should be taken into account in an assessment of the widespread and systematic scale of the attack upon the civilian population. The law only requires Your Honours find there is a widespread or systematic scale, but in the prosecution case there is both. Your Honours should be well satisfied that there are substantial grounds to believe that the following severe deprivations of fundamental human rights occurred, contrary to the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, to which China has signed but has not ratified, but which is in any case now customary international law. These are the freedom from arbitrary detention, fair trial rights, freedom of expression, association and assembly, and freedom to participate in the cultural life of the community. Now, one feature of life under Xi Jinping is the use of law to criminalize a range of traditional and social activities and to severely deprive the Tibetan people of their fundamental rights and freedoms, which then leads to their detention, their imprisonment, and so on. And the basis of the discrimination is their ethnicity, religion, or cultural identity, or their actual or perceived political affiliations. The use of guidelines and laws by the CCP, in the words of Xi Jinping, is to firmly follow the correct path of solving ethnic issues with Chinese characteristics. Examples of such laws are the 2014 notice, which is issued in Chengdu Prefecture, a 2015 notice in Malho, Qinghai Province, the May 2016 regulation on registration and management of social service organisations, the 11th of January 2018 CCP Central Committee and State Council issued notice on carrying out a special crackdown on clearing away organised crime and eliminating vice, and then following Xi Jinping's nationwide call to attack major forms of organised crime and mafia-like guns, the February 2018 notice of the Tibet Autonomous Region Public Security Department on reporting leads on crime and violations by underworld forces, which was issued by China's Public Security Bureau in the Tibet Autonomous Region. Now, this 2018 notice sets out 22 types of underworld forces that need to be reported. And examples of activities which fall within the ambit of these prohibited items include, for example, threatening political security, which we know is constituted simply by artistic endeavours such as making a film or writing a poem, having a picture of the Dalai Lama, associating with temples, teaching or spreading the message about the middle way, clearing rubbish or engaging in environmental endeavours falls within the prohibited activities, advocating for the retention of Tibetan language, and Your Honour has heard both on the case file and through the expert witnesses.
You have 4 minutes.
All right. Now, Dr. Richardson's hierarchical government, where the government has with the upper levels, and as such, these notices are to be issued with the authority of the higher levels of government. It's submitted ultimately that the evidence meets the substantial grounds to believe threshold for establishing crimes against humanity of imprisonment and persecution on the draft indictment. Your Honour's heard about self-immolation as a desperate form of protest utilised by Tibetans whose fundamental rights have been taken from them. Expert Dardam Sharlin's evidence is that in 2012, when Xi Jinping's presidency was announced, there was a rise in self-immolations, and there were 2 reasons why Tibetans resorted to this drastic and tragic form of protest. We need freedom in Tibet was one, and we want the return of our spiritual leader, the Dalai Lama. In the end, freedom is more important than life itself, in the words of Donda Wanchen. You know, there's a lot more to say about further guidelines and blacklists and things that have been issued by the CCP under the leadership of Xi Jinping, but since I only have a few minutes left, I will just sum it up by saying that on the issue of forcible transfer of the civilian population, being the children who are separated from their families, communities and networks to be sent to boarding schools, there is reliance on Human Rights Watch report, China's bilingual education policy in Tibet, and the report of the Tibet Action Institute, which is called Separated from Their Families, Hidden from the World, China's vast system of colonial boarding schools inside Tibet. Now, these hearsay reports contain many examples of interviews that were taken with people on the ground who suffered directly from these measures. But Your Honour's also heard evidence from Donda Wanchen, whose nieces and nephews were also subject to these boarding schools. And Your Honours have also heard from the expert witnesses who have spoken extensively about the measures taken to eradicate Tibetan identity. So, in my submission, there are substantial grounds to believe that a forcible transfer of a civilian population occurred, resulting in a crime against humanity in count 2, and as such, counts 2, 3, and 4 should be confirmed for trial. Now, I should add also, Your Honour, if I may be given an extra couple of minutes, that insofar as the crime against humanity in relation to a forcible transfer of a population group, it is a standalone crime that the prosecution has put on the draft indictment, but in the prosecution case, that also, in and of itself, constitutes one of the attacks upon the civilian population of Tibet, which should be taken into account in the crime for persecution. Now, I will conclude by acknowledging the very brave victims and survivors who have courageously turned up to these proceedings to give their harrowing account of
You
what
have
the
half a minute now.
is like on the ground. It's noted that Jigme Golik, that Dondat Wanchen and Nima Lamo have only been able to come to this court to give their evidence because of the very difficult position that they each individually took to leave Tibet. That is to say that if they had remained in Tibet, or rather, if they were still alive and had remained in Tibet, it is certain that this court would not have had the benefit of their testimonies today. I thank Your Honours.
That's it.
Yes.
Right, thank you very much. Exactly on time. I didn't have to use the gavel. That was very nice. I got ready to do it. The court will adjourn until 1:53. No, it's not. 12:53. Sorry.
Your Honor, don't we get to keep our 7 minutes?
Yes, you get to keep it. That's why we're adjourning until 12:53.
Understood.
Instead of 1 o'clock. 12:53. We've let the dining room know that we're going to be there early. So we're starting at 12:53. So you keep your 7 minutes. Right. Half an hour, exactly.
Half an hour. All right.
Hope you're enjoying your time.
integrity relating to the charges relating to the Tibet matter in the proposed indictment of Xi Jinping is that there is simply not sufficient evidence to establish substantial grounds to believe that Xi Jinping committed each of the crimes charged related to Tibet.
Each or any?
Any.
Carry on.
And it's for that reason, because it relates to any judge, that I won't be going through each of the elements that are addressed within the indictment. And the reason, Judge, that I'm addressing Tibet specifically, I've emphasized that twice, is because the proof that was offered for each of the matters that's before the court is different and distinct, I think, requiring the court to make independent decisions about each of the three matters. Judges, the criminal hearings are like a child's jigsaw puzzle. The puzzle isn't finished until every one of the pieces is found and put into its correct place, regardless of the good intention of the child putting the puzzle together and the parents' desire that the child succeed. It does damage to the integrity of the process for the parents to announce that the puzzle is complete if even one of the pieces is missing at the end of the effort. Many pieces are missing in this case, and like a child's puzzle, although we know what the puzzle should look like when it's completed, and has harmful and disappointing, and how harmful and disappointing it may be to those who wish that the puzzle were complete, we rely on those with decision-making authority to speak the truth. Here, that truth is that the prosecution has simply failed to provide all of the pieces of the puzzle. We've heard from a variety of witnesses. Some were offered as fact witnesses, and some were identified, and I'm using quotes, expert witnesses. All of the purported expert witnesses demonstrated and admitted their bias, lack of objectivity, and their testimony should be weighted given that fact. Mr. Jigme Golak testified, and he described his activities and experiences between the years 1990 and 2012. And as pointed out by our presiding justice, none of those dates that he was talking about were relevant to the actual charges in the indictment. They were for, as I understand it, context. And in 2012, of course, and luckily he was able to escape and went to Switzerland. So he wasn't in Tibet during the time period of the indictment, and his activities, once in Tibet, revolved exclusively around activism concerning Tibet. The weight of his testimony is the issue. Mr. Danda Wangchen testified, and he purported using his uncle's ID paper, and I'm not critical of it, I was sort of impressed by it, using his uncle's ID paper on several occasions to pick up his uncle's children at the boarding school and bring them home for their regular visit, which he explained occurred every 20 days and lasted for 8 days. You may remember that as well, I asked Wang Chen if he had children or family, and he said no, which was somewhat surprising to me because in 2012 he received the International Press Freedom submission, which reads, Wang Chen moved his wife, Lama Tso, and 4 children to India before beginning the film in order to protect them from reprisal by Chinese authorities. So credibility is an issue, and as you heard his testimony, I'm asking you to weigh his testimony leavened by the credibility issue that was so apparent in his testimony. And then we had another person, Naima Lamo, testify. That was sadly a fairly vigorous cross-examination on my part. Ms. Lamo reported that her uncle was charged with inciting a bombing and her cousin was charged with planting the bomb. You recall her denial that there was ever a trial, and then her subsequent admission after a difficult series of questions and answers that there was in fact a trial and a conviction after which her cousin was executed and her uncle was sentenced to a long prison sentence, but died 13 years into his sentence. Ms. Lamo soon left thereafter to pursue her desire to become a vocal activist on behalf of Tibet. And we know that there were many bombings in the early 2000s when this bombing allegedly occurred in and around Tibet. And I think we can all agree it might make sense that her uncle may not have discussed all of his activities with his young niece. We were told that her mother tried to get information about the death of her father, her uncle. But we also know that while her mother was upset about having not received that information, in fact, all of that detailed information was published by China in the press and was actually available at that time, although Ms. Lamo said that she wasn't aware of it at that time. We understand the hurt and heavy heart that the jailing and subsequent loss of her beloved uncle might have caused Ms. Lamo to endure, but, and this is essential, there is no indication that Xi Jinping committed at all to her loss of her uncle. We then heard from a purported expert, Dardin Charling. And as I discussed the expert testimony, I think that it's important, and probably you're aware of my view on this issue already, that you consider these experts, and as you do consider them, it's difficult for me to see how you would consider them as anything other than biased and politicized.
You will soon know.
Sorry.
You'll soon know.
Thank you. So Dardin Charling, no different from the other two witnesses, is clearly an interested witness with an agenda and a clear bias. She described her grandmother and grandfather as political targets and victims in Tibet. Her parents, she told us, escaped to India, and she was born in India. She currently holds official positions in the Tibetan government in exile. Not exactly the CV of someone who's going to be an unbiased and non-politicized expert. She also tried to convince us, and about this, I, as you know, have some skepticism. I imagine that some of you do as well. That the tragedy of 157 people who decided to self-immolate had no choice in the matter. I personally believe that we all have to take personal responsibility for every decision that we make, and those people made decisions. Perhaps you disagree, you're free to do that, but whether or not one agrees with the politics of those who make that decision, I personally found her no choice explanation of this extreme act to be a diminishment of, as the Dalai Lama said, a courageous act of protest. Finally, she also told us that classes in the bilingual boarding schools were mostly in Chinese, but that Tibetan was taught as well.
You can have no choice but to exercise courage, of course. Carry on.
I couldn't agree with you more as well. It's what I taught my children.
Carry on.
Thank you. Not surprisingly, Tibetan children are everything happens in bilingual schools. Focus is on learning a new language. And then we heard from the other purported expert, Langari Namgyal Dalkar, also the daughter of parents who are described as political prisoners who left Tibet for India in the 80s. She is also a politician. She's a member of the Tibetan parliament in exile for 8 years, was a former vice president and president of the Association for Former Tibetan Political Prisoners based in India. She describes herself as being active as a Tibetan freedom activist. She told us that anyone who reported that children attending boarding school had 8 days to go home every 20 days would have to be a stooge for Xi Jinping, despite the fact that that is precisely what Wang Chen explained to us that he knew, having done it from his own personal experience. Credibility and bias, that's what needs to drive the evaluation of expert testimony. Finally, expert witness Sophie Richardson spoke. She's very smart, highly educated academic who describes herself as an academic, as an activist. And when asked if anything that Xi Jinping had ever said or published called for violence against Tibetans, you heard what she said. Leaders never call out for that behavior. Well, she took that position despite being confronted with exactly those calls from leaders in Rwanda, Yugoslavia, and by Hitler. And she herself thereafter remembered that, yes, it happened in Cambodia as well. And we know that, of course, it's happened elsewhere countless times. Despotic leaders call out for exactly what they want. Her glossary that you now have, and that I spent some time with, is an obvious propagandized effort, complete with, if you haven't looked at it, I do commend it to you, creepy, dark cartoons to reinterpret and redefine as sinister the plain meaning of the words used by Xi Jinping to describe his efforts to secure and stabilize the country. And remarkably, she contradicted Darden Sharley by giving her expert opinion that no Tibetan is taught in boarding schools. Please take the time to read the short article in the defense submission entitled 250 Bilingual Kindergartens to be built in Tibet. You have that document. I will also note for you that I'm saving us 4 times of watching a video by asking you to look at a video that's within the material that was supplied by the defense. It's a 4-minute video. The title of it is A Day in the Life of a Tibetan High School Student. It's an interview with a Tibetan high school student who remarkably likes her life and likes the school that she's going to and enjoys going home to visit her parents and family. I do commend that to you. In many cases, we don't have the opportunity to hear from the defendant exactly what he intended the goal of his actions to be. In this case, we absolutely know as it relates to Tibet, unless that is, you're inclined to do what the prosecution is calling for you to do. When they say hot, they mean cold. When they say light, they mean dark. When they say yes, they mean no. They want you to be willing, as some of our experts are willing to do, to twist his words and invent sinister meanings to ordinary words. Here's what we know about what Xi Jinping can and will say. And I hasten to add, I'm only talking about Tibet here. When he wants to identify violent action towards a people, he's capable of doing it. You heard the quotes that he said about the Uyghur people. Those are facts that are beyond change. He has never made that kind of call about the Tibet people, and to twist the words that he actually has said about the Tibet people and their situation to mean something different when we know that he's capable of saying exactly what he means and does is, I think, avoiding a real obvious error. When Xi Jinping calls for a call to arms, he's able to do that explicitly. Now, and amongst the statements that Xi Jinping has made are a speech, which was in the defense submission entitled Speech at the National Conference on Commending National Unity and Speech and Progress in 2019. There's just no reason at all that a leader completely bent on the destruction of a disparate ethnic group would give such an inspirational and visionary speech. I truly commend it to you. It's not very long, and at least in your first reading, read it with an open mind of a man who is trying to say exactly what he means and does it so well. I can safely say that each of us, every one of us, everyone in this room would be proud to have the leaders of our own countries to give such a speech and embrace the values that it sets forth. As evidence of the continued efforts made by the CPC to operationalize those values that he sets out in that speech, the CPC has for years held work groups concerning Tibet. And in those work groups, they come up with strategies to achieve the very values that Xi Jinping has laid out for Tibet. A description of those values as well is in the defense submission entitled "What Were Discussed" at the 6th Central Tibet Work Symposiums, and I commend that to you as well. None of those work groups had ever called for either or operationalized human rights violations. In a Reuters report in 2021, the first visit by a Tibet Chinese leader in 3 decades, Xi Jinping, called for the embrace of all ethnic groups within China. And he noted that achievements made in poverty alleviation should be consolidated and expanded in coordination with the extensive drive for rural vitalization. He also stressed solid work in terms of the people's well-being, including employment, education, social security, medical services, elderly care, child care, and housing. I would vote for that man. On August 28, 2021, Xi Jinping explained that the party's ethnic work in the new era must be understood from the strategic perspective of national rejuvenation. He said that guiding all ethnic groups to jointly strive for fully building a modern socialist country must be taken as a crucial task of CPC's ethnic work in that area. If he had wanted to say something different, he could have and would have, and has. Forging the sense of community for the Chinese nation must be, he said, must be the focus of CPC's ethnic work in the new era, and the sense of national security and pride must be boosted. He went on to say, all ethnic groups must be equal. The banner of the unity of the Chinese nation must be held high. The system of regional ethnic autonomy, how does he finish this sentence? Must be upheld and improved. Fostering a strong sense of community for the Chinese nation, Xi Jinping said, is a critical element of safeguarding the fundamental interests of all ethnic groups. Even only through fostering a strong sense of community for the Chinese nation and all ethnic groups jointly safeguarding national security and social stability can the infiltration and subversion of extremist and separatist thoughts be resisted and the aspiration of the people of all ethnic groups for a better life be fulfilled. It just doesn't sound like a dog whistle to me. It sounds true. It sounds accurate from a man who can speak truth and accurately. He said that only in doing so can powerful ideological guarantees be provided for the prosperity and enduring stability of the party and the country. He said, urging efforts to forge a community with a shared future for the Chinese nation, with a higher sense of national identity and a stronger bond of attachment among the people. All ethnic groups should be guided to always place the interests of the Chinese nation above everything else. With their consciousness of different ethnic groups, let me repeat that, for the Chinese nation as a whole. Efforts should be made to see that the interests of all ethnic groups are realized in the process of the realization of the overall interest of the Chinese nation. That's what Xi Jinping said. So what's missing from this hearing? You know that I have a view of the experts that the prosecution chose to be on, but what's missing from the hearing is the voices and opinions of those truly unbiased experts who do not attempt to reinvent the clearly articulated meaning of Xi Jinping's words. Some of those individuals are described in an article, which you'll understand is attached in the defense submission, entitled "Tibet in My Eyes: Foreign Scholars Take on Tibet's Social Development
and human rights protection, which is which you have. In that article, Mohammed Iqbal, a scholar and lawyer, is identified, who has done an in-depth study which explains the positive growth and development of Tibet since it was in a feudal serfdom just a short 70 years ago. We're introduced to several educational experts, including Haley Andarji Wandalam, the vice dean of the law school of Deborah Marcos University in Ethiopia, who specializes in
You
women's
didn't
rights.
cross-examine Muhammad Iqbal at all about his Muslim biases, of course, but leave that for the moment.
We will leave that for the moment, on women's rights and studies. Also, Yogeshwar Ramkani, a former senior superintendent of the Nepal Police and chief leader of the People's Party of Nepal, and a British Tibetologist, Elaine Robson, who not only talks about the history of Tibet, but as well the treatment, Your Honor, of Muslim people throughout history in Tibet, as well as Sarbatam Shrestha, easy for me to say, president of Nepal's Arniko Society, which is an alumni association of scholars and experts who graduated from China and are engaged in various government and non-governmental organizations. Finally, the Austrian Buddhaologist and Tibetologist Birgit Kellner. A non-biased perspective on Tibet from these real experts who are unaffiliated with activist organizations is necessary to any critical analysis of this case. In the countless statements concerning Tibet, Xi Jinping supports an inclusive society that embraces a defined set of communal values. He calls for the elimination of crime and activities that disrupt and splinter a cohesive society. He attempts to stimulate the development of a community of Chinese who share common values, strive for improvement, and avoid disruptive, dismissive activities. His approach is a counterpoint to our increasing polarized, antagonistic, populist, segregated, and discriminatory societies that all of us live in. It may just be, open your eyes and hearts to the concept. It may just be that in a country of 1.45 billion people, with 55 distinct ethnic groups and 2,851 discrete geographical areas with discrete governments, which for centuries has been desperately poor and engaged in internecine battles and conflicts, that an overarching effort that prioritizes a singular focus on community, behavior, and a sharing of values is an approach that ultimately will result in what we all hope for, the greatest good for the greatest number of people. The law. You have not heard from the first two prosecution representatives who spoke here today, nor anything during the course of this trial. The words command responsibility. We're going to talk a little bit about that now. In this matter, since it's acknowledged that Xi Jinping did not himself commit any of the acts which are described in the proposed indictment, the only method of establishing liability is by use of Article 28 of the Rome Statute and related responsibility. It's acknowledged that President Xi Jinping had command responsibility for his government. For command responsibility to be established, several elements need to be proven by the prosecution. The failure to provide any one of the elements results in the complete failure of the prosecution to establish liability through the use of the command responsibility rule. Therefore, the prosecution needs to prove that Xi Jinping had actual knowledge or reasonably knew of the behavior charged in the proposed indictment. The prosecution presented absolutely no evidence at all of this element. The court cannot surmise a fact not put into evidence by the prosecution. And since this piece of the puzzle is missing, the prosecution's charge as it pertains to Tibet, speaking again about Tibet, in this matter must therefore fail. Second, the prosecution must also prove that Xi Jinping had effective control over the perpetrators, over the people who committed the crimes. The prosecution offered no evidence at all of this element, and therefore, since this piece of the puzzle is also missing, the prosecution's charge as it pertains to Tibet must also fail. 3, the prosecution must prove that Xi Jinping failed to take all necessary and reasonable measures to prevent the crimes, or that he failed to ensure that those crimes were investigated and prosecuted. In the hearing, the prosecution adduced nothing, no evidence regarding either prong of this element, and for that reason as well, since this piece of the puzzle is also missing, the proposed charge as it pertains to the Tibet matter must also fall. I want to be clear, this necessary finding does not mean that some other point in time, in some other fair and impartial hearing, such a charge could not succeed. It could, perhaps, if the evidence is put in front of the court. But today, in this hearing, on this evidence, the only finding with integrity is that as to the charge of crime against humanity in the prosecution's charges relating to the Tibet matter, the prosecution's evidence fails. Thank you all.
Thank you very much. Congratulations for keeping to time.
How much time did I have left?
No, you had credit time from your colleagues, but otherwise no time.
Thank you, Judge.
All right.
It's Mr. Rees.
Mr. Rees, here we go.
Proposal for the prosecution in relation to the allegations concerning the ex-UAI Uyghur people.
Right.
Your Honor, Wang Leizan was a policeman in mainland China for over 10 years when he was posted to Xinjiang in 2018. When he arrived, he has told you in his statement that he went on a round to arrest 300,000 Uyghurs, approximately. That was because he understood they were showing their cultural identity, that they were considered to have a different ideology. In some villages in Xinjiang, the whole population of a village was taken to the concentration camps, he has said. He testifies that he saw firsthand how Uyghur suspects were treated differently and harsher from other people that he had to deal with as a police officer. There was, he says, a national Chinese policy to arrest Uyghurs because he and his colleagues were told they were automatically to be considered as terrorists, as enemies. He has said and confirms that Uyghur prisoners are tortured. He accepts that he has witnessed Uyghurs being tortured, but has said that despite the obvious risks to him, that he has had to flee, he feels compelled to speak about it. Uyghur prisoners forced to kneel, being punched, plastic bag being tied over their heads, forcing Uyghurs to state that they were rejecting their religion, forcing them to sign confessions that were wholly false, admitting that they were terrorists and other false accusations, and to denounce their relatives and friends as terrorists. He tells you that the methods of torture that he witnessed included the using of electric rods, something which you have heard about directly from somebody who has suffered that indignity and torture. He says that this was encouraged by central Chinese government. It was, according to Chinese government policy, systematic, he says, as a result of the collective definition of the Uyghur people as terrorists. The severe repression and torture against the Uyghurs, he says, was encouraged by the Chinese government. He was taught to see Uyghurs as the enemy. He was told to invent wholly false reasons to make an arrest appear plausible, to invent false suggestions of legality. This was done as a matter of routine, as part of a widespread systematic attack. From the words of a Chinese police officer who has the courage to speak about it. You've also heard from a teacher that was taken to the camps. Seiragal Southbay was in 2017, contacted by the state and informed that she was to go to teach Chinese in a so-called education camp. She was conveyed herself as a teacher, not as a detainee, but as a teacher, by having 4 police officers place a black hood over her head so that she was unaware of the location, and taken to the camp, which she describes as terrifying. She recounts in her role as a teacher, detainees being subjected to extreme mental torture, detainees being handcuffed and shackled, the shaving of men's and women's heads. What she was asked to teach in these camps was the propaganda of the Communist Party, in particular, the speeches of Xi Jinping. She describes having seen the conditions in the cells of tens of inmates in one cell. People required to try to get whatever sleep they could in little more than 1 square meter to themselves that they could find on the floor. The toilet facilities amounting to little more than a plastic bucket in the corner of the cell. Songs being forced upon detainees to praise Chairman Xi Jinping, interrupted only by armed police from time to time entering the classroom, marking and dragging away detainees from time to time to a room that she learned was known as the dark room or the black room. She could hear the terrified sounds of people crying, screaming and begging as they were being taken away from their lessons praising President Xi Jinping. And she would see some of her so-called students returning on occasion with severe injuries, fingernails being pulled out, some she never saw return. She, a teacher, saw the Black Room with her own eyes and what went on in the Black Room. On one occasion, she recounts she was asked to help with the work as a security guard. When new detainees were attending, an elderly lady was brought before her who was terrified in floods of tears because, as she told the teacher, they made up accusations against me, please rescue me. This teacher had the humanity to hug this new elderly female detainee who was crying in distress. The response to her act of humanity was to accuse her of breaking the camp rules, taking her to the Black Room, showing her the types of torture instruments that we have heard about from numerous others: tiger chair, electric stick. They put her in that chair and they tortured her with the electric stick, and they beat her, the teacher, because she showed humanity to one of her so-called students. She saw women being subjected to sexual violence and rape. On one terrible occasion, she was present in the hall that was used as an assembly hall to sing songs of praise about President Xi Jinping, together with 100 other people, when a girl no more than 21 was forced to confess to another false allegation and was then subjected to a gang rape by the police in that room. She recalls hearing, please, that girl, rescue me, please, help me, please, in the same room where the songs praising President Xi were sung day in, day out. You've also have the statement of Zumrit Dawat. She was somebody else taken to a camp. She gives a detailed account of the horrendous treatment that she suffered at the hands of the authorities when she was in detention. When she was released, she says that the indignities, the horrors, did not end at that point. On her release, she was part of a crowd that was ordered to attend a flag-raising ceremony in November 2018. At that flag-raising ceremony, somebody on behalf of the state read out a direct order that 200 women present and listed on that order were to be sterilized. Her attempt to try to resist that order only led to her husband being threatened to be expelled if she did not undergo that coerced surgical procedure. The police car, in the end, collected her physically and took her to the hospital. She said she was terrified. She was not given any information about the operation. She lost consciousness and awoke to real serious pain. You have heard also of the attempts by the authorities to force, coerce, cajole people in the ex-UAR to produce videos. You have heard direct testimony from a witness who spent 4 days being interrogated with a script as to what to say being drummed into her, with numerous attempts made to take a video of her saying, in effect, how wonderful everything was until the authorities were happy. You have other examples, plenty of examples, of the same attempts to create, fabricate wholly false propaganda videos in the bundle. One example, you have at section A, part 2, page 117 onwards. You have, in relation to part 2, this case, testimony from, I think, some 60 eyewitnesses who have individually shown extreme courage in the force of an organized campaign by the state to intimidate and silence them. The effect of that extreme courage has been to make, the prosecution says, absolutely clear, consistent, uniform picture of horrendous state-sponsored treatment of Uyghurs in the ex-UAR from 2014 onwards. What does the defense say? What has China said? You do have submitted at an earlier stage, I'm not quite sure I understand at the moment what evidential status it has, but it was provided to you, a document called Annex A. I understand that you have it, nevertheless. It's entitled Fight Against Terrorism and Extremism in Xinjiang, Truth and Facts. And it's from the permanent mission of the People's Republic of China to the UN office at Geneva, dated the 31st of August 2022. And again, it would be absurd to suggest that that was submitted to the UN without the approval of President Xi Jinping. So what does he say in that document? Does he show concern? No. He dismisses that witness testimony, that canon of eyewitness testimony, independent reports, expert analysis, as a throwaway remark. It's all lies. He then goes on, the document then goes on, to spend pages and pages just setting out, really, that the ends in any event justify the means. It was all part of a security clampdown. The ends justify the means, that old chestnut. And then, to the extent that there is any attempt to deal with the evidence, he resorts to slurs. He slurs eyewitnesses, and he slurs experts, dismissing them simply as pawns of anti-Chinese forces. The document dismisses the Xinjiang papers and the China cables as simply a farce orchestrated by the West. It resorts to suggesting that there's an attempt to make black white and to confuse, he puts interestingly, right and wrong. And yet, in the same breath, when one looks at some of the detail, we see that the document actually supports entirely the prosecution case. He embarked upon a campaign of mass internment using arbitrary detention at the entire discretion of the Chinese state. At page 31 of 131, we are provided with the definition of manifestations of terrorism. The very last of those subcategories is simply described as other terrorist activities. We are given a definition of extremism in this document at page 36 of 131. Of those 10 items, the last, number 10, again, is predictably other acts. And we are given a definition of radicalization at page 37 of 131. We again get, in the final of these lists, the catch-all other remarks and conduct. But before we get to that point, we also get intervening in normal cultural and recreational activities such as watching radio and television, overgeneralizing the concept of halal, wearing the burqa or other symbols, instigating religious fanaticism through irregular beards or name selection, publishing, printing, distributing publications, deliberately interfering or undermining in the implementation of a family planning policy, and other extremist remarks and conduct. The document entirely supports the existence of and the plan to set up a mass internment camp that not only arrested people, detained people who had committed criminal offences, but also, in the words of this document, potential perpetrators, people who potentially might commit offences in the future, and indeed people who might have previously been in a camp, but they did not regard, to use their words, the person as somebody who took advantage of the opportunity afforded to them, which they hoped the person would cherish, to repent and re-enter society and rejoin their family. That's what the camps were used for, to remove people from society and from their family, and they could do that at will. The prosecution says that there is overwhelming evidence, certainly substantial grounds to believe, that the crimes alleged to have been committed in XUAR during the indictment period have been committed. The prosecution says that there is also, the evidence also demonstrates, we say clearly, that certainly to the requisite standard of substantial grounds to believe, that President Xi Jinping bears criminal responsibility for inciting, for inducing, for ordering, for assisting, for contributing to and committing those offences. In 2014, President Xi gave those speeches that we've seen, calling for the war on terrorists who we have heard is a term used, it's equated to the Uyghur people. Called for war on them. He called to unleash the weapons of officials to show absolutely no mercy to them. He called to erect walls, iron walls and nets which would spread from the earth to the sky in relation to them. He presided over, we have the evidence, a high-level party meeting where leaders were discussing the policy of promoting population optimization, which led to directly asking cadre homestays to visit and stay with Uyghur families. He appointed, in August 2016, Chen Quango to bring the same methods that he had used in Tibet to the Uyghur people, to expand the security measures and the detention sites and the internment camps in the region, and to distribute President Xi's own speeches on the campaign targeting the Uyghurs, ordering officials to round up everybody who should be rounded up. In June 2017, Zhu Hailin issued his directive, again forwarding President Xi's commandment. They're there, round them up, he said. And the only instance we have of party members, state government officials, being punished, being treated for their failing to toe the line, breaking the rules, is not punishment because they have broken the rules, the real rules, the rules that require people to be treated humanely, but punished because he did not follow the will of President Xi and treated the Uyghurs as an underclass. And to make it perfectly clear what the position is, President Xi Xinjiang doesn't seek to say, does he? Well, I'm not responsible. In September 2020, at a time when, of course, he knew, of course, the whole state apparatus in China knew, indeed, the rest of the world was waking up to these matters taking place in the ex-UAR. President Xi gave his unequivocal and very public approval to what had happened on his watch under the ex-UAR, saying that the practice, not the policy, but the practice in Xinjiang was completely correct. He started that widespread, systematic and genocidal attack on the Uyghurs in 2014. He presided over its implementation in all its horrendous forms, and he praised that implementation at the end. It may properly be said, on the defence's behalf, that the prosecution case does not include allegations of mass killing, but the law is clear that such an allegation is not an essential ingredient of the crime of genocide. Indeed, the article that has been supplied by the defense by Mr. Jeffrey Sachs and William Shabbos, that article admits that that is the case. They concede the point. It's a matter of law. Mass killing is not required. In 2014, President Xi, a despot who called for exactly what he wanted, called the Uyghurs rats, a disease, a sickness at the heart of Xinjiang that was to be eradicated. He presided contentedly over a genocidal system that treated them in that way. Years later, looking back over the effects in Xinjiang, he praised his own work. These counts, this indictment, these counts should, and this court, should confirm the charges. This court should confirm the charges in relation to the indictment, specifically in relation to the ex-UAR. If there is an answer to these charges, President Xi Jinping can give it at a trial. Thank you.
You have a little time, and I'd like to ask you one question, which I hope you will answer in 1 minute.
I'll do my best.
What do you say about the argument that the experts are all biased?
Well, I saw Sophie Richardson give evidence.
Yeah.
I can't speak as to the other witnesses, although I've seen on paper that everything that their CVs looked to me to be wholly independent and impartial. Of the three witnesses that I saw give evidence, Sophie Richardson, to me, looked like somebody who was incredibly knowledgeable about her field, who appeared to have integrity and impartiality, and who was concerned about focusing only on the evidence.
And the doctor this morning?
Those remarks,
The doctor this morning?
and indeed, before we get to Dr. Tobin this morning,
Yeah.
Dr. Zen's also.
Yeah.
The attempt to, there's no criticism implied in this,
Yeah.
but there was an exploration made of his own private religious matters, but it was not suggested, wasn't asked whether they had any impact on his conclusions. And one only has to look at what is only a fraction of Dr. Zen's work that you have. I think you have about 300 or so pages of incredibly detailed analysis. You've only got to see that his answer when Mr. Guy Smith quite properly said that he was only exploring these matters with Dr. Zen. Dr. Zen said, I don't mind. I'm an academic, you explore away. You question all you like. But I follow the evidence, I've done a huge amount of research, and all I'm telling you is an independent, impartial analysis of the facts.
Thank you. I
And
think
in
you've covered it.
relation, to Dr. David Tobin,
Yes.
his evidence in my submission
Yeah.
was clear. It was perfectly understandable, not only in an academic sense, but on a common sense level. Of course, words have different meanings depending upon the context of them. His evidence in my respectful submission was not challenged as the detail. There's no suggestion that his work is wrong or its conclusion. It wasn't suggested that there were alternative interpretations that were the correct interpretations. Instead, we had some exploration about a metaphysical consideration about the meaning of words, particularly in the context of trying to understand a language that is not only doesn't share the same alphabet as ours. And in that respect, I didn't see anything in my respectful submission that would suggest the court can do anything other than rely 100% upon the unchallenged conclusions, frankly, of Dr. Tobin and Dr. Zen's, and for what it's worth, Dr. Richardson and the other experts also. Those are my submissions.
Thank you. All right. The defense, you have 35 minutes now. So you're going to finish exactly by 2:30.
Don't worry, Your Honor. Don't worry. With your permission, I'm going to remain where I usually have been operating from. Most challenging endeavors that I've been involved in. And the reason for that starts with the brevity of preparation. I am not criticizing whatsoever anybody, and certainly not criticizing this panel. Whether or not it would have been different, meaning would I, as a defense lawyer, been in a position to operate with, discuss with, perhaps obtain information from my client had they received adequate notice is something I can't answer. But I am sure that we can all agree that 4 days of notice is woefully short and gives rise to the concern, just the concern, that perhaps the hearing wasn't as fair as it could have been. Now, is that a fatal flaw in what's going on here? No. Does it establish a detriment? Yes. And is there a reason why that is said? Once again, yes. Because of the manner in which the statute is written, to the extent that it can be relied upon. If for the accused is in absentia, the court will appoint counsel. And that counsel has the opportunity to defend in whatever fashion they believe is appropriate in the absence of instructions. It's kind of a tall order when you're dealing with the leader of a relatively large country. It's kind of a tall order when you're dealing with any accused. As a matter of fact, the inability to have instructions makes his job that much more, shall we say, challenging. However, within the context of all that I was presented, I did have a relatively decent standard of proof, a fair standard of proof, which has two component parts. One, is there sufficient evidence to establish substantial grounds? And two, can that be believed? That the suspect committed each of the crimes charged. So we're left in a situation of having to make a determination, which is your determination. I don't envy you. As to the quality of the evidence you received. Most of it is anonymous. The witnesses that we heard here in court, and I salute each and every one of them for their courage. I salute each and every one of them for their openness. Do not establish international crimes. They may well have established some criminal behavior. I would not argue with that. Not behavior charges by an international body, which is what we purport to be here, citizens of the world. In that regard, is the testimony of those three witnesses sufficient for you to believe that you have sufficient evidence to establish substantial grounds? I submit to you, that it's small. And interestingly, it's the bundle that Mr. Reese, learned opponent, relied upon in order to make his closing submissions. And then above and beyond that, it is his reliance on the experts. And specifically, and I'll go in reverse order, we have Mr. Tobin, who quite frankly told us in no uncertain terms that in order to understand what was being said, it wasn't the plain language, but rather his interpretation of that language. And his interpretation of that language was special and understood in such a fashion that it could only be used to make a determination that the words spoken were words that established an ill intent, a specific intent to harm, to hurt, to destroy. But as a matter of fact, those were not the words that we had. We ultimately reached a stage where, with Mr. Tobin, it really made no difference at all what question I asked him. He refuted all of them. Is that evidence, is the quality of that evidence sufficient for you to rely upon? And when I'm talking about the quality of evidence, then of course you're dealing with the issue of perception. You're dealing with the issue of interpretation. And ultimately, the quality of the conclusion. I cannot be a judge of that. That is something I leave in your hands. I think you know my view. Unfortunately, Mr. Reese misapprehended, and in his argument it became clear that he misapprehended why I was asking Dr. Zentz the questions that I was asking with regard to the religious position and his religious philosophy. Considering the standard of proof that you have to work with, what I was attempting to do is not criticize his practice at all. I believe, as a matter of fact, I said I wasn't criticizing his practice, but rather to leave for you the question of whether or not an individual who was part of one of the most active anti-communist organizations in the United States, coupled with a profound faith, up to and including rapture, which means the ascension of each and every individual in the world back to God, might cause difficulty in an objective analysis. And in that context, where you have the juxtaposition of a deeply religious man and a deeply, using the term of Mr. Shi, scientific state, a deeply anti-Christian state, whether or not the evidence that is produced for you was sufficient
Of course, the Uyghurs were not Christians.
I'm sorry?
The Uyghurs were not Christians, were they?
No, but whether they be Christians or not,
Yeah.
what they were and what they are, and what was contended by the experts that they were, is a group of deeply religious people.
I must
I-
confess
and I-
that I was born a Muslim. I don't know whether that disqualifies me from being a judge here, but you
No,
made
it
no
doesn't.
application for
Of course.
recusal. Carry on, yeah.
Of course it's not, I assume you jest with me, because you understand that that's not the thrust of my argument. Because the thrust of the argument deals with the intellectual and philosophical underpinnings of the work that's being done. And it is in that context that particular examination and that particular question is being posed to you. The category in which an individual speaks determines their thought, admittedly. And Dr. Zentz's speech and his thought includes a particular philosophical belief system. Many of the words that were used here by the prosecution, viva voce, were hot words, emotional words, words that give rise to a visceral reaction to the subject matter at hand. I commend that particular kind of use of language, and I commend that particular kind of argument to be made. But in this situation, that emotion and that visceral reaction is inappropriate. In this world, the question is objectivity. Can you be objective? That's why we have courts. That's why we have these kinds of proceedings, because we do not wish to rush like the mob to a judgment. We do not wish to be influenced by emotion when making the kinds of decisions.
But you agree that absolute objectivity is a myth.
Do I agree that absolute objectivity is a myth?
Yeah.
Yes, in the same way that I believe that absolute truth is a myth.
Yeah, I
In
agree
the
with
same
you.
way that I believe, that almost any definition that involves absolute is a myth. Yes.
So there's no such thing. You can be as objective as possible in the circumstances. But carry on.
One would hope. No evidence that was presented by the live witnesses that you could see and hear establishes international criminal behavior. The purpose of these hearings is for you to determine whether or not there is sufficient evidence to believe President Xi committed each of the crimes charged. We submit they did not. And I believe that is well within your time frame.
Right.
So it's,
Thank you. I was right not to worry. I did believe you and you said don't worry. Let me consult with my colleagues and tell you at what time we are going to be ready.
I don't know, 3:30 certainly.
3:30? Colleagues, are all of you okay with 3:30?
3:30.
3:30. We'll be ready at 3:30. And I refer to all of you as colleagues in the true sense of the word, because we are legal colleagues. Right. Thank you very much, colleagues. We will adjourn until 3:30, by when you will have a verdict. And I'm sure that all of you, each and every one of you, are absolutely uncertain what the result is going to be. The court will adjourn until 3:30. Okay. Good afternoon, everyone. As all of you know, I am Zach Yaqub, the president of this tribunal. The two venerable judges with me are Judge Fonseca and Judge Stephen Rapp. What will happen today is that Judge Rapp will start the proceedings, setting out the general framework and the general counts, followed by a detailed evaluation of count one, the crime of aggression. Then Judge Fonseca will follow to deal with a number of counts relating to the area of Tibet. I will be speaking finally, talking in detail about the crimes committed in the XUAR, which is the Xinjiang Uyghur Autonomous Region, a discrete area in which a number of crimes were committed. In fact, the largest number of crimes were committed in that area. And we will address the issue of whether there is enough evidence or substantial grounds as the relevant section requires to warrant the issue of this indictment and whether we confirm it or not. So without further ado, I hand you over to Judge Rapp.
Well, thank you very much, Your Honor. First of all, I'd like to thank the attorneys, counsel for both the prosecution and defense for their zealous advocacy and for the presentation to us of thousands of pages of documents disclosed by both sides, and for their skillful examination and cross-examination of the witnesses and their closing submission. Certainly want to thank the witnesses, both factual and expert, who came here to testify before us and who testified by video link. We announced that we will be posting on our website whatever indictment that we do confirm. And of course, this is not a trial, it's an indictment process, a confirmation process, similar to what the ICC would conduct and will conduct in the Coney case this fall, done under the provisions of ICC statute Article 61. And I, as Judge Yaqub said, will be dealing with the Taiwan and related issues that under which are grouped under count one, the crime of aggression. Judge Fonseca will be dealing with counts 2, 3, and 4 of the indictments submitted by the prosecution on the 24th of May for crimes against humanity in Tibet, and Judge Yaqub counts 5 through 12 alleging genocide and crimes against humanity in Xinjiang. There is the issue, of course, first and foremost, of the responsibility of the accused. This is not a case against China or its people or against other persons other than the president of the People's Republic of China and the leader of the Chinese Communist Party, Xi Jinping. And we find that there's substantial evidence both for his direct responsibility and for his superior responsibility. One, in that he is, in the nature of Chinese society and under the communist system, he is someone that has effective control over those that may be more directly acting in this case, and that he is certainly has notice of what they have doing, the direct orders and declarations that have been made, the clear policies that have been defined and followed very closely, as Xi Jinping thought. He is directly responsible. So now we turn to the particular area of the case that was presented first here, and that's the allegation of aggression by the Chinese government under the control of the defendant, Xi Jinping. And the prosecution has alleged 2 different ways in which that crime could be committed, and we're entitled under our statute to look at both of them. The first comes to us from the International Criminal Court statute, reflecting the Kampala amendments to the ICC statute, which came into effect in 2018. And those are that specific statute basically, and I will quote it, defines the crime of aggression means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political and military action of the state of an act of aggression which by its character, gravity, and scale constitutes a manifest violation of the UN Charter. Under that section, there are 7 defined acts, A through G, and each of them require action against a state. Then we have also the customary law that comes to us from Nuremberg and the Tokyo Tribunal, the latter of which China was an active participant and had a judge among those that judged the leaders of Japan for what is referred to by the current government of China as the anti-Japanese war. Section 5 of that statute specifically criminalizes crimes against peace, namely the planning, preparation, initiation, or waging of a declared or undeclared war of aggression, or a war in violation of international law, treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. Note here that whereas the ICC statute requires acts against a state, the second way in which this crime can be committed does not require actions against the state, but could be acts as part of a war or the preparation of a war, which are contrary to international law, treaties, agreements, or assurances. We first have to turn to the question of statehood, because obviously if Taiwan is not a state, then no state, no individual can be guilty of aggression against it under the provisions of ICC statute 8 bis. And as you've heard from arguments of counsel, there are 2 recognized theories for the definition of statehood, one being constitutive, the recognition by other states or by multi-state bodies. The second is declarative, which is more of a de facto or reality-based determination that comes to us from the Montevideo Convention, which requires that particular territory have a permanent population, that territory be defined, that it has a government, that it has capacity to enter into relations with other states. The defense has argued that we should look in particular to the United Nations and its approach to the status of Taiwan. We would note, however, that what the United Nations has done, in our view, has been erroneous in the past and remains so. And we would particularly note that between 1949 and 1971, the United Nations persisted in not recognizing the state of the People's Republic of China at a time when clearly Mao Zedong and the Communist Party were in control in Beijing and in effective control and acting in every way under the Montevideo Convention as a state. Nonetheless, the UN for those 22 years, for political reasons, did not recognize that state or allow it to take its seat in the United Nations, to which mainland China was entitled. The same error committed for basically the last 53 years by, again, for political reasons, not recognizing of China independent of the government in Beijing. It's the one thing that and it was noted by Judge Crawford, a learned judge who sat on the International Court of Justice, now sits on the Iran Claims Tribunal here in The Hague, has noted that the one thing that's really lacking in the Taiwan context is that it has itself failed to clearly declare that it is a state. However, we see in the various exhibits that have been presented by the parties a clear indication that any explicit declaration by Taiwan of its independence would lead very directly to an invasion. And indeed, as we heard, even for persons to come here before this court and assert the right of Taiwan to be a state or to assert its statehood could subject them at some point in the future to criminal prosecution and possibly even the death penalty. Under these circumstances, we find that that requirement, to the extent that Judge Crawford thought there was one, and it doesn't appear in the Montevideo Convention, doesn't apply in this individual case, and that Taiwan is a state for all intents and purposes as required by Article 8 bis. Even if it is not a state, we conclude that waging a war against Taiwan or its status would be contrary to international understandings. And there we turn to what is indeed, and this is of course challenging because the status of Taiwan has been one in which the parties and the various blocks, power blocks in the world have used the term one China policy to frankly obscure and to avoid the resolution of the status of Taiwan and to maintain peaceful relations between China and Western countries. But that does not in fact help us. The question is, what understanding was there in terms of how that status would be settled? And we've heard recently, and it's only been very recently, and it was in a speech that was played here in the courtroom, the Chinese leader, Xi Jinping, the accused herein, recently talked about China reserving its right to settle the status of Taiwan by the use of force. We have looked, of course, at situations where China has explicitly stated that it would never use force, and frankly do not find those statements in its declaration. However, in documents that follow the various communiques between the United States and China, the three that were provided to us by the defense, we see the U.S. stating that clearly there is an understanding that depends upon the continuity of China's declared fundamental policy of seeking a peaceful resolution of the Taiwan issue. And particularly in the statement by President Reagan that followed the communique of 1982, the U.S. willingness to reduce its arms sales to Taiwan is conditioned absolutely upon the continued commitment of China to the peaceful resolution of the Taiwan PRC differences. It should be clearly understood that the linkage between these two matters is a permanent imperative of U.S. foreign policy. It is essential that the quality and quantity of arms provided to Taiwan be conditioned entirely on the threat posed by the PRC. Both in quantitative and qualitative terms, Taiwan's defense capacity relative to the PRC will be maintained. So fundamentally, the United States has said that there is an understanding that this status will be resolved peacefully, and it's only the worry that it might not be that causes arms to be provided, and as we see with the increased language from President Xi Jinping, we've seen those increased arms being provided by Taiwan. Fundamentally, we find that if China were now to violate that understanding and in fact invade Taiwan, that would be contrary to an international understanding. Secondly, and more persuasively, we find that the statement made by former Chinese leader Mao Zedong reflected international law when it comes to countries that have been colonies. And it was noted earlier, at least until the 1940s, this was the consistent position of the Communist Party of China, that Taiwan was a territory like the Philippines and like Vietnam that was then a colony. In the case of Taiwan, it had been a colony of China since 1895, like the Philippines had been a colony of the United States since 1898, and Vietnam a colony of France since the late 19th century. And each of them at the time that they threw off that colonial bond was entitled to self-determination. And it didn't make any difference that Chiang Kai-shek and his forces came there, a relatively small part of the population, most of it being native Taiwanese, and established control in 1949 and that a lot of time has passed since then. We see as well, for instance, in the case of East Timor, that has been a colony of Portugal for some almost 500 years, when Portugal had a revolution and gave up its colonies and Indonesia occupied it. That was nonetheless viewed as illegal, and 25 years later, the people of East Timor were entitled to decide on their independence. Of course, at this stage, the people of Taiwan have not yet decided to have a referendum on their future, but any effort to interfere with that right of self-determination would be contrary to the Charter of the United Nations, Article 73, that makes self-determination and self-government by people of former colonies a paramount object of the United Nations. So now the question turns to whether there have been acts that violate the Rome Statute or that violate customary international law. And understand in doing that, both of these statutes refer to planning and preparation in addition to actual execution. But we will first turn to the question of execution of what has actually been done to date. And here we look to three sections of Article 8 bis of the ICC statute that refer to acts of aggression that have been alleged by the prosecution. One is bombardment by the armed forces of a state against the territory of another, or the use of any weapons by a state against the territory of another. We don't find that there has been bombardment specifically, but we do find, based upon the evidence, that there has been use of weapons by a state against the territory of another, that being Taiwan, but also, as we've had evidence, territory represented by the flag ships of foreign states. Those are also part of its territory, and so that we also have acts against Australia, the United States, and Philippines that have been presented. The second section is the blockade of ports or coast of any state by the armed forces of another. Though the periods have been relatively brief, these periods that have followed certain actions to which China objected, like the Pelosi visit or the inauguration of the current president of Taiwan in May of this year, have led to these short periods of blockade. And then D, the third one, an attack by the armed forces of a state on the land, sea, or air forces, or marine or air fleets of another state. We saw evidence of that certainly in the photographic and video material that was presented to us. I will deal first with the ICC statute in terms of whether these acts of aggression constitute then the crime of aggression. And as the consul correctly quoted me, and as I participated in the CCW Ukraine Tribunal some 16 months ago, noted that this is a two-step analysis. And I particularly quoted the declarations that accompanied the ICC's approval at its review conference in Kampala, Uganda, of the amendments to the ICC statute that include 8 bis. And those particular understandings are 6 and 7 in the resolution of approval. It's understood that aggression is the most serious and dangerous form of the illegal use of force, and the determination consider their consequences in accordance with the Charter of the United Nations. The 7th understanding was, it is understood that in establishing whether an act of aggression constitutes a manifest violation of the Charter of the United Nations, the 3 components of character, gravity, and scale must be sufficient to justify a manifest determination. No one component can be significant enough to satisfy the manifest standard by itself. So now it falls upon us to determine whether the acts that have actually been executed, or whether there has been proof, sufficient proof, of planning or preparation to commit such other acts, that they together would constitute a manifest violation. Frankly, in this regard, the Chamber, after careful consideration, has determined that that standard has not yet been met. That acts which to date have not resulted in the loss of a single human life. We recognize that they were provocative and in fact intended to intimidate the people of Taiwan, but that the law requires the most serious and dangerous form of the illegal use of force. We find that the conduct of the accused as a leader of China was wrongful under international law, but not criminal at this stage. The second question is, do we have a violation of customary international law coming to us from Nuremberg? And keep in mind there, we're not talking about these acts, which can be shooting at a ship, using water hoses, doing all sorts of things that could, in fact, be aggression against the territory or the fleet of another state. We're talking about a war. And a war of an interstate nature would be, as we've seen in Ukraine and elsewhere, a thing that a conflict between these two states that would be of enormous consequences to the population of both. And in terms of the definition of war and where we cross the line, as we often do when we deal with issues such as war crimes in an international armed conflict, we know the seriousness of a war. We cannot say, based upon the proof that's been adduced by the prosecution, that the acts of China and its government of placing missiles pointing at Taiwan, when obviously Taiwan has substantial defensive weapons as well, can be viewed at this stage in the absence of clear indications of planning amphibious landings, preparing the kind of military force necessary and the deployment of that military force into a situation where it could potentially invade and defeat Taiwanese forces and the forces of countries that may come to its assistance. We don't find that yet we have proof, sufficient proof, that China's conduct, even with the language of Xi Jinping, that it's reserving its right to use force, that it has made a determination to use force, and that it has moved to the level of planning and preparation. We hope that our decision in this regard will be a clear warning to China and its leaders that further action in this regard, that movement toward preparation for invasion, that other acts of a more serious consequence could in fact cross that line, and that should be avoided in the interest of the peace and security of the entire world and the respect of international law. For these reasons, we do not confirm count one of the indictment, and I turn now to my colleague, Judge Fonseca, to deal with proposed counts 2 through 4.
Thank you, Judge Rapp. As Judge Rapp mentioned, I'll be looking at the charges count 2, 3, and 4 related to Tibet. And before I start, I want to say, as the evidence indicates, the accused is the General Secretary of the Chinese Community Party and is the President of the People's Republic of China. The court heard of how the accused has had effective authority over the PRC since 2013. It has also been submitted that the system of the People's Republic of China and the accused is intrinsically involved in the planning and preparation of the policies in the PRC. As the court heard this week, the civilian people of Tibet have experienced widespread and systematic attacks, including attempts to erase their cultural, linguistic, and religious practices and identity, restrictions on free expression of opinion and belief, on their movement, of torture, and a large number of Tibetan children being forcibly moved to Chinese-run boarding schools. The testimony and the evidence presented to court highlight the systematic and organized nature of these practices by the accused. As such, the present session, and I will be looking at whether there are substantial grounds to indict the accused on count 2, that is crime against humanity of forcible transfer of children. Count 3, the crime against humanity of imprisonment or other severe deprivation of physical liberty. And count 4, which is a crime against humanity of imprisonment or persecution. And before I start, just to be clear, Article 7 of the ICC statute sets out that this has to be widespread or systematic attack directed against any civilian population with the knowledge of the attack. Thus, there are two elements, that is the contextual element and the mental element. This means that it should not be random, accidental, or isolated acts of violence, and be committed in furtherance, and it needs to be committed in furtherance of a state or organizational policy to commit an attack. In addition to the ICC statute, attention is also on whether violations were committed under customary international law. The court heard of specific instances that I will set out briefly below. First, we heard from victims and expert testimony on the implementation of the colonial boarding schools and its impact on Tibetan children and their families, the psychological and emotional trauma, and the long-term impact on Tibetan identity. Previously, subjects taught in the Tibetan language saw a change of policy under the leadership of the accused, with education presently being solely in the Chinese language. The court heard evidence indicating to at least 1 million Tibetan children affected by this policy. It is, as a result, children of Tibetan minorities are forced to complete education in Mandarin Chinese. This has resulted in Tibetan children losing the ability to communicate with their parents and their families in their Tibetan language, and further contributing to the assimilation of the Tibetan identity. Secondly, we heard of evidence that speaks to the targeting of Tibetan monasteries. This has been on multiple fronts, including the destruction of several monasteries and violence targeting Tibetan monks and nuns, restrictions placed on Tibetans' access to religious sites and religious gatherings, changing the practice of Tibetan Buddhism to Chinese Buddhism, persecution of Tibetans for religious activities honoring the Dalai Lama or possessing his image. Such practices can be viewed as a deliberate policy aimed at dismantling Tibetan religious and cultural identity. Thirdly, we heard evidence that speaks to multiple forms of restrictions on free expression of opinion and belief, on movement, assembly, and association. Further evidence indicated to other serious violations, including the use of torture, that includes the denial of basic services to prisoners and reports of enforced disappearances when families were unaware of the whereabouts of political prisoners. Furthermore, the court heard of state policies with questions is to create uniformity, with it eradicating other cultures, religions, and languages. Further, narratives such as lasting stability, national security seek to provide legitimacy to the policies of the PRC and the accused. The tenure of the accused has marked a period of increased institutionalization of repressive measures against Tibetans, with a clear focus on eroding Tibetan cultural identity. Despite the official narratives that include economic development, unity in the motherland, the renovation of cultural sites, the preservation of language and culture, and the eradication of extreme poverty, evidence before the court indicates to a concerted attempt to eradicate the Tibetan identity and culture and to integrate Tibetan identity into the dominant Chinese identity. Moreover, the dire conditions in the Tibetan areas have witnessed several reported instances of self-immolation, and as indicated to the court is indicative of the desperation and oppression faced by the Tibetans. Considering the vast evidence before the court, we believe there are substantial grounds to infer a widespread and systematic attack directed against the civilian population with knowledge of such attacks. Thus, the court confirms count 2, 3, and 4 of the indictment. Finally, we also want to recognize the testimony of several victims and witnesses who have come before the court this week. Their courage, their determination, their resilience spoke volumes, and that has contributed to informing us of our decision. We also heard of continuous challenges, including challenges of coming before this specific hearing. And we commend those who have come before us. We recognize their resilience and their determination, and we want to thank you for that. Judge Jacob.
Thank you very much indeed. I will be dealing with a rather limited area, and that is why the idea of a widespread and systematic attack, which of course all the elements of the crime described by Judge Fonseca apply in relation to the crimes concerned in this area as well. But the interesting thing about the area with which we are here concerned is we are concerned with a defined area consisting of between 1.5 and 2 million people. It is the Uyghur population, and therefore there was a widespread systematic attack in the sense that the widespread and systematic attack that we are talking about here included the whole of the region. Not a single square meter of this area was spared. Ironically, the area is referred to as the Xinjiang Uyghur area. It is an area which is supposed to be independent. It's an area which is supposed to be by itself. It is an area which is supposed to have a measure of independence for that area. And yet, that area has given the opportunity to the Chinese president, and I agree completely that the Chinese president had complete control. He is the right person to be the accused. The system in China I would describe as a dictatorial system in which the president does exactly what he says, what he can do, that everyone does exactly what the president tells them to do, and anyone who acts contrary to the directives of the president will get punished immediately and automatically. So the point really is this, that it can never be said that the president was not responsible. He has made statements making it very clear. The idea is to create a single Chinese nation. Because the idea is not to allow independence. And of course, we know that the Uyghur population is a Muslim population. And the difference in the religion is between the Dalai Lama and the Muslim religion is complete. But the problem is that in the way in which we see society and the world, international law requires the recognition of all peoples and the recognition of self-determination, the freedom of religion, the freedom of conscience, the freedom of belief. And the idea of creating a single nation might well be a wonderful idea, provided that within that single nation, one would allow difference to exist properly and appropriately, as many countries do, as South Africa does, and many other countries do. But here, the Chinese culture has to be developed. The Chinese culture has to dominate. Chinese culture has to triumph over all other cultures. And if other cultures, other religious groupings, including the Uyghurs, need to be destroyed, so be it. The conduct, which will be described in the various counts just now, of course, was wide and systematic and was planned and involved state apparatus from beginning to end. And it has continued, it has differed at different times in terms of the number of people affected. But it has been a continuous attack. Sometimes attacking concerning 500,000 people, sometimes concerning 1 million people, at other times concerning 1.5 million people. But the exact numbers are irrelevant. The point is that there has been a continuous, vigorous attack, which varied in intensity from time to time, depending on what sources were available, what the conditions on the ground were like, and so on and so on. But from what has happened on the ground, the intention of, I would say, annihilating completely the Uyghur community and assimilating them into a single China is something which is contrary to all notions of international law. There has been criticism by the prosecution about the witnesses, criticism in fact that all the witnesses were biased, that they believed in particular things. We have listened to the expert evidence with considerable care. And as far as we are concerned, all the judges are concerned, everybody, every professor, every religious person, every expert have their biases at one level or another. We all have certain beliefs and certain prejudices. But the issue is not whether people have biases or prejudices. The issue is not whether they belong to particular religions, whether they believe in particular religions or not, whether they have a particular way of life or not. The issue is whether in their reasoning, the experts have let their own beliefs, their own biases to intrude upon the appropriateness of their conclusion. We have taken account of these biases very carefully of all these experts. They have honestly admitted their biases, and we are satisfied that although these biases exist in the same way as every human being has a bias, we are satisfied and completely satisfied that the reasons for which they gave evidence, the reasons on the basis of which they came to their conclusions, had nothing whatever to do with it. We've examined their reasoning carefully, we've examined their opinions carefully, and we have come to the conclusion that there is no way in which it can be said that any of the experts were so biased. Their reasoning was clear, their method was clear. We've examined them with the greatest of care, and I want to thank the experts for the care they've taken in ensuring that they did not get in the way, and they put up with the cross-examination, which sometimes, and I suppose understandably, pushed them rather hard on their biases and so on, but they stood firm conceding their biases on the one hand, but on the other hand, making it quite plain that their biases have had little or nothing to do with the conclusion, that the conclusion is based on reasons which have nothing to do with the biases. So it is quite clear that the aim has been to use educational institutions, imprisonment institutions, imprisonment camps, all these institutions. You see, a prison was not merely a prison in XUAR. A prison was also an educational center. A prison was also an indoctrinational center. A prison was also a way of persuading people that they must do things differently. And we have clear evidence that during imprisonment or during school or during punishment, if they agree that they were wrong, if they agree that the Chinese president is the most wonderful leader in the world, if they agree that the Chinese leader is right in everything he says, they will obviously be released from detention, released from jail, be promoted to work in the presidency, and undoubtedly earn a great deal of money. So that is the kind of society we are dealing with. There are no nuances here. There is nothing that is left to chance here. We had evidence of teachers in these institutions, workers in these institutions, victims in these institutions, and the evidence is clear that the aim of annihilating the whole community in the sense of a genocide was very, very clear, and that there were also separate counts committed, also, of course, with the general aim of annihilating, basically, or supporting the genocide and abandoning the community completely. But over a period of the last 11 years, the government has continued in its campaign. There was a great deal of evidence, of contextual evidence about things that happened before. And there was obviously great objection to this evidence. But the conclusion to which we come is that that was contextual evidence, and it is quite clear that things didn't get better or easier during 2014 to 2020, 2013 to 2024. Things got consistently worse as the security establishment became more and more adept at doing things. So that they operate more subtly in achieving their objectives without regard to the human cost involved. Indeed, we heard evidence that a teacher who felt sorry for an old lady who had been tortured was punished in a punishment chamber. Now, that is not the kind of society which lives and let lives, that believes in freedom of religion. The sanitization is something where it's China for Chinese people only. In other words, you see, it is different from one America. Although I don't agree with the United States of America at all, but in America, there are people of many, many views who live and survive. The Chinese idea is different. The one China is a population from one end to the other, who believe in exactly the same thing, who sing the same songs from the same hymn book. The problem is that there is a variety of songs. It may be a little bit more interesting, but there is only one song, which is that the president of China is the man who is a wonderful person. He is a representative of China, and everything he does, all the evil he perpetrates, all the suffering he causes, all the torture is right because the ideal is right and the end justifies the means. For these reasons, we have no hesitation in coming to the conclusion that there are definitely substantial grounds for confirming all the grounds or all the counts in relation to conduct in the XUAR in Xinjiang in relation to the Muslim Uyghur community. The count of genocide, obviously count 5, has been very clearly established, contrary to, of course, Article 6 of the Rome Statute. Count 6 is a crime of humanity of imprisonment, and I've said that many people have been imprisoned over a period. Imprisonment is almost like the order of the day in that region. It's not as though it happens sometimes in some area. It is a hallmark. It is an indication of what China is about. Imprisonment and severe deprivation has been all the time through physical liberty as well. The imprisonment is complete, and of course, as I said earlier, you remain imprisoned, you continue. It's not simply imprisonment. It's a very flexible area where you get imprisoned, you get educated, and you get trained, and your mind gets changed and controlled at the same time. And that is the problem, that the imprisonment is there, but it's not mainly or only imprisonment. It is more than simply imprisonment. It is imprisonment aimed at achieving a particular purpose, which makes that imprisonment obviously part of a wide and systematic plan designed to achieve a particular result. Count 7 is a crime against humanity of torture. We've heard very much evidence of torture in prison. Indeed, if you don't agree with the system, torture in prison is the order of the day. And I would be surprised. The thing is that torture occurs in many countries. And I'm sure that torture occurs in this country as well. But the point is that in these other countries, torture occurs from time to time, and it is a matter of degree. But once you are a Uyghur person, torture is the life of the day. Whether you're in prison, whether you're out of prison, mental and physical torture in the area are complete. And then count 8. Again, another crime of humanity, of rape, sexual violence, and enforced sterilization. Again, men or women who were Uyghur were not and are not recognized again as human beings. This is why these are very serious crimes of humanity, widely and systematically. The attack is based on the basis that these people are not worth being human. They are sterilized, they are raped at will, as if they're nothing. And that's the problem of the way in which this happens. There is no remorse. There is no thought about whether this should be done or not. There are no feelings of guilt at all. It is as if a paper or an object or a piece of iron, or even worse than that. That is the problem. That is in count 8, which has very clearly been established, wide, systematic, planned, operationalized in every way. And then count 9, forcible transfer of the population. Of course, populations are transferred from one area to another, to an area where the Chinese culture, as it is called, dominate. Again, not for the sake of the transfer of population on its own, but with the aim of genocide, with the aim that this population will be cured of its so-called animalism, of its lack of all other problems. And that is why it has carried on as well. All the other counts actually fall in the same category, as you will say. Count 10 is a crime against humanity of forcible transfer of the population, which I've dealt with already. And that follows automatically from everything I've said. Count 11 is the crime against humanity of persecution. And of course, from everything I've said, it is obvious that there has been a continuous persecution of the population in their communities, in boarding schools, in camps, in educational camps, in prison. The persecution has been unending for this community. And the fact that the community continues to exist is a miracle second to none. Count 12 is a count of enforced disappearance. Of course, many, many people have disappeared. And that's one of the ways in order to demonstrate, and again for the purpose of enforcing the change in the thinking. See, people who believe in a particular way, who have the nerve to stand up to the system, will disappear. Of course, the prosecution said they have the choice. Well, they do have the choice. The only choice that people have is to move out of the area, but they'll be followed even there. But the other choice they have is to say, we abandon our beliefs completely. We say that the Chinese are right in our criticisms of us. So there have been much enforced disappearance, and there is no doubt about it whatsoever. So these are all the crimes that have been established. They are serious crimes, and I would like all these crimes actually to be taken together. It is not separately. Even the counts in the other region, they're not separate counts in separate regions. Nor is the Taiwan count different. It is a general way of oppression. It is a flexible, varied way of oppression. And therefore, we have no hesitation in confirming the indictment. We hope and trust that the Chinese government will take note of this judgment, because that is the only way in which we can see, if it's possible at all, some kind of change taking place. They will take note and ensure that they begin to ensure that freedom of religion and freedom of conscience and freedom of belief are important. That in the real world, we live and let live. We don't kill to live ourselves. We don't eat other animals so that we can get food. We don't eat other human beings so that we can get food. We live and let live with tolerance and respect for all. And fundamentally, that is what is lacking, and that is what has resulted in these very, very serious crimes against humanity. So thank you very much to the lawyers on both sides. They have given us wonderful argument to listen to, and it has been a privilege to be part of this process, to hear all the evidence, and to put it together. The only thing to hope for is that the international community take note, and that the relevant international courts will come to the conclusion that it is important that China be prosecuted. One of the problems is that the decision of prosecution is a political decision. A political decision which cannot be taken lightly by even the United Nations against a powerful country like China, with a huge population that it has. That, in my view, and this is not necessarily what is agreed between the judges, that, in my view, is the real reason. So we have no hesitation in confirming all the counts, except of course, count one, save to the extent fortified by Judge Rapp. Thank you very much. I have come to the end of what I have to say.
Thank you.
Registrar, where do we go to from here?
Thank you very much, judges. Thank you, defense counsel, prosecution counsel, citizens of the court of the world, second tribunal, China tribunal, all stand.
Thank you, Steve. That was good. Thank you, Bhavani. This is the last time.
Okay, Ms. Amin.
I got you.
Okay.
Well, we are done.
See, I gotta go 5 minutes later.
We did discuss like preparation.